Any mention? Item number 1.
Yes. What is the Devnan?
So, in this case, we filed this decision, but there was few days delay.
How many days delay?
203 days.
203 days.
103.
What's your explanation? You have any objection? You're appearing for respondents.
My lord, sole respondent. They have not cited the reason why for the delay. They have not explained it for the entire 103 days. And the application has been preferred. If your lordship see the cause title, very well, will see the cause title. The application for condemnation of not even citing the provision of law also, my lord.
That's all right. This is a proceeding. Yes, you have any objection?
That's the only objection we have, my lord, apart from that.
You have paragraph E, paragraph C. What's this? Paragraph 4C. What was the counsel or station followed by identification?
So, this much.
Mr. Devnath himself, my lord.
Immediately, 1910,
October, my lord.
immediately, yes,
my lord.
forwarded the branch higher authority. Appellant immediately contacted counsel on 9, that means on October.
Then they are saying that vindication was sets in after that was October. They have received the 19 October, I think. They have received the certified copy, my lord.
Where's the objection?
Lord, I have filed my objection, my lord. On 21st October itself, my lord. I raised all the plea, my lord, right from paragraph 4, 5, 6 onward. 7.
What's the matter about? What is the relief given to the
My lord,
respondent?
I was dismissed from service because I was absent without leave. In actual, my lord, I have not extended my leave. That is the entire crux of the matter, my lord.
Yes. We will conclude. Yes. Third Learned Counsel, Mr. Adirwan, on the prayer for condemnation of 103 days. Stop. As also Mr. Al-Kiriam for the sole respondent who has objected to the application for condemnation. Stop. Seeing the reasons as set out in the application, especially paragraphs 4, paragraph 4. Stop. Considering the explanation, in the concept of this court, the delay can be condoned. Accordingly, the delay of 103 days condoned, and the appeal be listed for consideration. So, registry to diarize and register the appeal, and list for the appeal of this case disposed of.
Hearing. Item number 2.
Privilege.
You read the matter today. Yes, then start.
So this is a case of dismissal of service, Lordship.
You are serving as
Constable, Lordship.
constable.
Yes, I'll just go to paragraph 25, Lordship, page 102, Lordship.
Judgment.
Yes, Lordship.
25.
Yes.
25? Or
Page
appeal memo?
102, paragraph 25 of the judgment, Lordship. 102.
Sorry. Looks like ready with the matter to you know.
Lordship, yes.
Then we'll not engage in a futile exercise. Yes. Para 25.
Paragraph 25, Lordship. This court has taken note of the narration of the facts and circumstances of the case between the parties and the contention made by the respective counsels in support of their case. The facts as stated above need not to be reiterated except if required for the purpose of reference. The petitioner in defense of his contention would seek to impress upon this court that the entire disciplinary proceeding proceeded against him is vitiated inasmuch as proper procedure has not been followed as mandated by rules of law and procedure in this regard. Here, Lordship, first irregularities that 9 of the disciplinary rules, conduct rule was not followed, which mandates that at the time of delivering the show cause must contain the charge of allegation, the charge as well as the list of witnesses and the documents which the department wants to rely to prove the guilt of the delinquent. That was not given. Only the charge was given, but the list of witnesses as well as the list of documents was never supplied. That is the major irregularities. I have raised all those. Certain instances in this regard have been cited, one being the petitioner was not afforded opportunity to know the list of documents and witnesses relied upon by the department to prove the article of charges against him. Such charges being mandated in the show cause notice, charge memo which was issued upon him. The learned counsel for the petitioner would submit that Rule 9 of Meghalaya Service Discipline Appeal Rules 2011 provides for the procedure, and violation of the same has rendered the entire proceeding against the petitioner vitiated. Another instance cited by the learned counsel for the petitioner is that the disciplinary authority pressing the charge against the petitioner had appointed an inquiry officer, and in order to prove such charges has also brought in 4 prosecution witnesses which have been examined and have also proved certain documents exhibited during such proceeding. However, if the contention of the petitioner that as it mandatory in such a disciplinary proceeding that apart from the inquiry officer, a presenting officer should also be appointed, no such presenting officer was appointed, and it was the inquiry officer himself who has put questions to the prosecution witnesses. No opportunity was given. Here, Lordship, the inquiry officer himself has examined the witnesses and cross-examined the witnesses. There was no presenting officer. So thereby the inquiry officer has assumed the role of prosecution and as a judge, Lordship. That also violates Rule 9 of the discipline rules, Lordship. Now, yet another anomaly in the whole process which is pointed out by the petitioner is that after examination of the prosecution witness, the inquiry officer had preferred the inquiry report, but a copy of which inquiry was not furnished to the petitioner before passing of the.
So the thing is that your entire challenge only on the procedural.
I am not on merit, Lordship. Only on
then what about your own conduct?
I am not on merit, my lord.
What about your own conduct?
Own conduct, Lordship.
What about suppose sometimes inquiries may be necessary to go and be gone into also. If a delinquent, he as per the charges given to him, he says yes, I've done these things.
My lord will rule, my lord.
Then,
but it is not a case. It is not a case that the punishment was inflicted after the admission, Lordship. When I filed my explanation, they found that my explanation.
Are you saying that you never got even a positive show cause against the proposed disciplinary proceedings?
My lord, that was not given. In fact, the copy of the inquiry report was not given. The copy which I have obtained through RTI, that is after the dismissal, after the input order has been passed. These are the major irregularities, Lordship. Number 1, list of witnesses, list of documents. Then presenting officer was not.
Okay. Fine, that's one part, but the other part regarding your own conduct, that's what the court wants to know.
Lordship, true, Lordship.
Whether it's necessary at all to,
my lord will kindly appreciate one thing, that MPDA Act, lordship, whatever may be, if he has committed the offence also, if there is a procedural irregularities, lordship, the court will not go into the conduct of the parties, lordship. Here, lordship,
your conduct in
yes,
the
lordship.
proceedings with
Here,
regard to admission.
here, lordship, the case of dismissal, I have served 24 years. 24 years, lordship. Punishment provides, this is a major punishment, provides compulsory retirement. Looking into
Are you challenging quantum, or you're saying
that was also one of
you're on what you have to be clear what you want. I challenge the entire saying that it's possible irregularity is there, so the whole thing is vitiated, bad, which has to be set aside and fresh inquiry.
my lord, that is
Or you want another thing is that fine, I have admitted to my absence, but then the punishment meted out to me is disproportionate to my
that was also another challenge, lordship. That was also I have
gone into it. I'm just asking.
Yes, I have
emphasized that.
Yes, lordship. That was also one of the challenge in my writ petition, that it was disproportionate, because the punishment, the compulsory retirement also prescribed for measure. This is also measure punishment. Instead of giving that dismissal, that the department ought to have given that compulsory retirement, considering my length of service. That was also one of the grounds of challenge in my writ petition, lordship. Here, lordship, what happened? Now, show cause was given. Then, based on the show cause, I have given my response, lordship. I'll just read out my what is the erroneous conclusion arrived by the learned single judge, lordship. Lordship will find. I'll just start paragraph 30, lordship. The state respondent, on the other hand, has countered the above contention of the petitioner to say that it was on record that the petitioner, on receipt of the third notice, so-and-so, dated so-and-so, and he has joined on so-and-so. However, he was issued with a show cause notice along with the statement of allegation on so-and-so. In replying to such show cause notice, the petitioner had filed his written statement dated so-and-so, so-and-so, wherein, in reply to the article of charge 1, that as in regard his absence from general roll call with effect from so-and-so without any leave or permission from the competent authority, he had admitted to the same, though his...
How many days were he absent?
56 days, lordship.
That's all?
Yes, lordship.
Cumulative?
Yes, lordship.
No other earlier absence?
Earlier absence was there.
Then? For this proceedings only 56 days?
56 days, lordship.
The earlier days were condoned?
Earlier days, because there are so many absence without pay, lordship.
So you're a habitual absentee?
That I have to admit, lordship.
Yes.
That I have to admit. Now, lordship, there are 3 charges, lordship.
Yes.
Number 1 charge, that I was absent for a period of 56 days. Then number 2 charge, lordship, that despite receipt earlier notices, I did not resume my duties. And the third charge is that it was only after receipt of the third notice I have resumed my duties. My lord, so far as 56 days, lordship, I cannot deny, lordship. I have to, because this is on record, lordship. Now the second charge, that despite receipt of the first and second notice, that I have not joined the duty, that charges never been proved by lordship. Never proved. Neither any witness was examined who says that yes, I went to his place and I have served the notice. Now,
so you said you never received them?
I never received, and it is in fact, lordship.
That time you absent without leave?
Yes, lordship. And first notice, second notice, I did not receive. When I received the third notice, then I joined. And after joining, they have issued show cause, then I...
Okay, yes, continue.
Then this court has also perused, this is the operative part of the judgment, lordship. This court has also perused the relevant records produced by the department, wherein it was found that the details of the disciplinary proceeding against the petitioner. It is evident that the petitioner in his written statement had indeed admitted of being absent from duty so-and-so. Even in his statement before the inquiry officer recorded on so-and-so, the same admission was reiterated. Nothing on record would show that the petitioner was caused to make such admission. There's no more so, since is as indicated, the admission is found in 2 places, one in his written statement and the other in his statement before the inquiry officer of the so-and-so. Of the cases cited by the respondent in this regard, the case of chairman versus so-and-so, the relevant paragraph, lordship, this is very important. indisputably the respondent was a habitual absentee. He, in his explanation in answer to the charge sheet, pleaded guilty, admitted the charge. In terms of Section 56 of the Indian Evidence Act, charges having been admitted were not required to be proved. It was on that premises the inquiry proceeding was closed. Before the inquiry officer, he did not submit the explanation of his well-being, of his mother being ill. Despite opportunity granted to report to him, he did not so. He failed to explain even his prior conduct. Now, Lordship, what happened here, Lordship? In that case, what happened? Based on the admission given by the delinquent, the proceeding was closed. Then, based on an admission, then punishment was inflicted. But my case is otherwise, Lordship. My case is like, had there been a punishment based on the written explanation given by me, which the department says that I have admitted, that thing would have been different. They have concluded, they have continued the proceeding under the relevant provision of law. Now they cannot come and say that I have admitted, that is why I am giving the punishment of dismissal. No, that was not the case. Now, since the department has initiated the procedure under the relevant provision of law, we have to go through whether there is any deviation or not. If there is a deviation, then that will vitiate the proceeding, Lordship. Now, again, in a case of chairman.
So, what is wrong with the decision being processed of the inquiry officer?
My lord, the decision making process, list of witnesses, list of documents.
Leaving that aside, so you want to submit that, notwithstanding your admission, which you have called for, and they have gone the extra mile by even after you admitting, said fine, maybe this poor fellow has something to say, giving opportunity.
The charges were one of the charges that is vital.
Was that summarily then?
My lord, one of the charges, vital charges, that despite that charges number
fine,
2.
Your first charge of absence you have admitted. Second charge you said show cause not served.
Yes.
Yes. Then
not show cause, Lordship. That first and second notice for
first, second notice for absence.
Yes.
Yes, not served.
Not served.
Then
third, that it was only after receipt of the third notice I joined.
The third charge is what?
That is the charges, Lordship. My lord will.
First charge is the absence.
Yes, Lordship.
The second one is.
I'll come. I'll just on the last part, Lordship. Last part of the judgment. After that, I'll come to the charge, Lordship.
Let's go to the charges first. Come.
Lordship will find at page 30, Lordship.
Yeah, let's go to the charges first. Everything stems from there. How the
page 30.
Yes.
That is the show cause notice dated 10th of February 2021. The charges number 1, Lordship. That while you were posted at BN headquarters, you were found absent from general roll call with effect from so and so, without any leave or permission from the competent authority. That in spite of issuing several notice in your address available in the service sheet record, you failed to report, neither report nor resume your duties. Third, it was only after issuing third notice to resume duty, you reported for duty on so and so without any supporting documents after remaining absent for a period of 56 days. Thus, you have failed to maintain full devotion to duty and thereby committed gross misconduct and dereliction of duty and violated rule so and so Meghalaya's service conduct rules.
He's admitted to the first charge. So what is there? When you see his statement is out. They have he's not disputing that point. Yes.
Lordship, after that I'll file my, the next page 32 is they have given the allegation of charge. My lord will see there is nothing, the list of witnesses and the list of documents. And if my lord will see the inquiry report, they have exhibited so many documents, that notice as well as that register of roll call also. The next page is 34 is my written type copy of my written submission, Lordship. 34. That is the sole basis of my dismissal of my writ petition, Lordship. Paragraph 1, Lordship, that Madam, as per article of charge number 1, I was found absent from general roll call with effect from so-and-so without any leave or permission from the competent authority is true and admitted. But reason behind was that I was suffering from illness and the same could not be reported before the competent authority.
Yes. Yes.
Now, where is the other charge, Lordship?
Yes. Yes, Mr. Shulai.
This is your lordship.
I don't think you have any authorities in support of your case.
Pardon, Lordship. I have, Lordship.
You have authorities?
I have, Lordship.
Let's hear Mr. Shulai first. Yes.
Lordship is a very bad police personnel, your lordship. He remained absent, your lordship, without any permission. Earlier also the same thing, your lordship. He was an habitual absent.
That I have to admit.
You admit.
Lordship, yes.
Service record I cannot deny, Lordship.
Lordship, for the moment, if lordship kindly come to page 48, your lordship. Kindly see, your lordship. Then lordship kindly see the page 50, the detail of
48.
punishment.
48.
48, your lordship. These are the past record of the writ appellant, your lordship. Then lordship kindly come to detail of punishment drill awarded to him, your lordship. Detail of suspension from service awarded to him. Then lordship kindly come to page 51, your lordship. Detail of the departmental proceeding drawn up against him.
It was 99, so DP drawn up against him.
Lordship, yes.
I mean, 2008 also.
Lordship, yes.
2011 also.
Yes. That's why, lordship, I've submitted that is a very bad. He is an indisciplined police personnel, your lordship.
What's his age now?
And
He is, Lordship, hardly left for 2-3 years, Lordship. He is going to retire, Lordship.
lordship, so far the contention raised by my friend, your lordship, I have made a note, your lordship, point by point. I am also relying on one of the judgment passed by this honorable court, your lordship.
Not actually.
Lordship, that unauthorized absent, your lordship. Lordship, I kindly come to page 2, your lordship, that decision rendered in Ashok Kumar Singh, your lordship, para 8, your lordship, that has been reflected. Lordship, I'll just read only the the sentence in the middle.
It's all right, Mr. Shulai.
Lordship.
The disciplinary.
Then lordship kindly come to page 5 of that note, your lordship. Further,
Yes.
furthermore, this honorable court in a similar case titled Amzad Khan, State of Meghalaya. This is the judgment rendered by your lordship. The petitioner, being a member of the discipline force, is in fact required to maintain higher standard of conduct. In this context, the decision of the Honorable in the case of so-and-so, which was reported below, applies to the case of the. One cannot ignore the large number of cases which come to this court of members of uniformed forces remaining absent from duty without any reasonable explanation. Whenever action is taken, the usual plea is of having been ill or some such false pretext, and even fake or false medical certificate are produced in support of such a plea. We would not have taken a serious view of the matter had it not been a case of a constable belonging to a CRPF remaining absent for an indefinite period. Even if we assume that the respondent was suffering from depression and was being treated as an outdoor patient, the medical certificate produced by him showed that he was restored to normalcy on so-and-so, yet they did not choose to report for duty. The order of this, so this itself disclosed the hollowness of the claim to the respondent regarding mental depression, which we claim to have suffered. Then, Lordship, another decision also, that is 2011, Lordship, kindly come next, Your Lordship. A member of the discipline force, Your Lordship, dismissal is the right punishment, Your Lordship. Then, Lordship, so far admission of charge. In my humble and respectful submission, Your Lordship, since the red appellant had admitted the charges, Your Lordship,
So
and
no prejudice cause.
in view of Section 58 of the Evidence Act, Your Lordship.
No, the inquiry report is not given to him.
No, Your Lordship, that is not correct, Your Lordship.
It was given to him.
Yes, he got it. He was aware, Your Lordship.
I got it
He was
after
aware of
through
the
RTI, Lordship.
Lordship, assuming
have-
but not admitting that the inquiry report has not been furnished, Your Lordship, then he must plead prejudice, Your Lordship.
Yes.
He must plead prejudice. That is the finding of the Honorable single judge, Your Lordship. No prejudice has been caused to the red appellant, Your Lordship. Then, Lordship, kindly come to page 11 of the note, Your Lordship. So far, non-supply of inquiry report, Your Lordship. Lordship, kindly come somewhere below, Your Lordship. If for infraction, Lordship, a full sentence from below, Your Lordship. If for infraction of a constitutional provision, an order would not be invalid unless prejudice is shown. We fail to understand how requirement in the state rule of furnishing copy of the inquiry report would stand on a higher footing by laying down that question of prejudice is not material therein. Then, Lordship, next, Your Lordship, is at page 12, Your Lordship. This is the reiteration, Your Lordship, that prejudice has to be pleaded, Your Lordship. Then at page 13, Your Lordship, that para 20, Your Lordship, this is the same, Your Lordship. Then, Lordship, kindly come to page 17, Your Lordship, so far non-supply of list of document. Lordship, the state has relied in the decision rendered by the Honorable Guwahati High Court, Your Lordship, that is in 2005, Your Lordship, para 14, Your Lordship, that has been reproduced. So also, Your Lordship, in one of the cases, Mohidlal Sharan versus State of Meghalaya. This is 2006, Your Lordship. May I read it, Your Lordship?
That's all right. Issue authorities.
So my humble and respectful submission, Your Lordship, there is no merit in the writ appeal. It's liable to be
I'll give the
dismissed,
compilation, Lordship, because I have cited 5-6 authorities, Lordship.
You said you had authorities.
Yes, Lordship.
That's it.
No, I have some more, Lordship.
What is it? What do they say?
This is
Just place them.
non-appointment of presenting officer. That is, the judgment talks about, Lordship, division bench judgment of the Guwahati High Court, Lordship. This matter went to Supreme Court and Supreme Court later on dismissed. That is the exactly fitting our case, Lordship.
Yes. Yes. Your case is on a different footing.
My lord, that is why, lordship, because what my learned
So I
senior,
read your authorities today or not?
I'll file by way of compilation, lordship.
When?
I'll,
Within 1 hour.
yeah, I can, otherwise tomorrow is everything ready. I'll just put pagination and file it, lordship.
Because you wanted to actually pass
Then
the
otherwise,
rental judgment. Okay, we'll give you supply authorities.
I'll supply tomorrow, lordship, because I'll put the pagination and the marking. Here, lordship, I'll just bother lordship, paragraph 32 of the judgment, lordship.
This judgment?
Yes, no, lordship, in the interim judgment.
Okay.
Because the dismissal of my writ petition, the writ petition was dismissed based on this reasoning given in the judgment, lordship.
Yes.
Paragraph
That
32.
regarding non-supply of inquiry report.
No, lordship, no, lordship, no. That is with regard to
Para 32.
paragraph 32 of the judgment.
Yes.
Again, the case of so-and-so, lordship, operative part. It has been time and again is said that it is not open to the High Court to examine the findings recorded by the inquiry officer as a court of appeal and reach its own conclusion, and that power of a judicial review is not directed against the decision but confined to the decision making process. In a case such as the present one, where the delinquent admitted the charge, no scope is left to differ with the conclusion arrived at by the inquiry officer about the proof of the charge. Lordship, in the absence of, lordship, this is very important, lordship, next line. In the absence of any procedural illegality or irregularity in conduct of the departmental inquiry, it has to be held that the charges against the delinquent stood proof and warranted no interference. Here in this case, what happened? He has admitted, and the entire departmental inquiry was concluded based on the admission given. There was no procedural irregularities. But here the case is different, lordship. That the inquiry was not concluded based on my admission in the written explanation. Here there is a procedural irregularities. There are lots of procedural irregularities, lordship. So based on the relying on the judgment, the writ petition was dismissed. My case has a different footing, lordship. My case is, I'll just supply, lordship. That is.
Yes. But will you sit again? Yes. You want to list it again?
Lordship.
Tomorrow?
Lordship, day after tomorrow, lordship. In next week, lordship.
We're just asking you to place authorities.
Yes, I'll just place.
That's the only thing. Because otherwise, we have heard you substantially and would render the judgment in open court, but since we don't want to.
My entire argument that charge
adequate opportunity.
Charge, then let it be fixed on next week, lordship. Next week I'll file my written that.
No need, actually, notes are not necessary. You can file, since he's filed a note, you can give your bullet points if you want. Otherwise, it's not necessary. Yes. We didn't ask for this also.
Then next week, lordship, I'll make it.
Yes, hearing is substantially concluded. Learned counsel for the appellant prays about to place some authorities in support of this case. Stop in consideration thereof this matter after 1 week. Yes.
Apply, your lord.
Item number 3.
Yes. What happened to that matter, Dr. Mozika?
Malid, the instruction I have received that department is file a review petition, Malid, before the Honorable High Court of Manipur.
No, before the Manipur High Court, what happened?
Department is file a review petition, Malid.
Review petition. What is the status of that case?
Review petition is pending, Malid.
Then, Mr. Musa, I think you'd be advised to go and seek a remedy before. You can't seek remedy in two different forums.
My lord, in fact, if I may submit, my lord.
Yes.
The cause of action will not lie there. I filed the initial.
Well, that should not lie there. You have an order from Manipur High Court where the direction for release of your. This is gold, right?
No,
gold.
Yes. My lord, I'm not on the question of release at all. I'm not on the question. In fact, that order becomes infructuous. That order becomes infructuous because it is merged with this adjudication order, with the impugned order here. Now, if I raise this there, they'll raise this argument that the order there, the provisions of 110(2), clause 2 of the Customs Act are not applicable, and it is merged with this impugned order, man.
You mean to say
That's
that
my
an order of the
my-
Manipur High Court has merged with the executive order passed by the respondents?
No. No. The order, my rights under 110(2) of the Customs Act, my rights under 110(2) of the Customs Act have merged with the impugned order in this proceeding. The impugned order was passed in order to frustrate the Manipur High Court order, man. And because
No, you see, Mr. Musa, you have adequate,
Yes.
Avenues to pursue your remedy, in the sense that you have an order of Manipur High Court. Where is the explicit direction? Where's that direction? Which page is it? Last time when we heard the matter, we were not aware of that because we had not seen the file.
No, my lord, I produced it. I
Then?
produced Annexure
Of course,
812
it's there. Annexure 11.
812. Annexure
Annexure?
812, my lord.
812, okay.
812.
Where's the direction
812?
at page? At page
86 one.
86. See,
My lord, that right.
see, one thing we can't understand is how the thing is that,
Yes.
see, the last part says, in the result, the present interpretation is allowed, directing the respondents to release forward the seized gold jewelries to the concerned petitioners. Now,
Yes.
after this order, was in your favor, then why do you want to submit yourself to the fresh proceedings again? If they had
My
initial
lord,
fresh
it is
proceedings,
only-
then
my lord,
where
in
this
fact,
order had emanated from, your remedy lies in that court only.
No, my lord. In fact, I produced the pleadings before the Manipur High Court. If I may take your lordship to the pleadings, my lord. The pleadings are available. My relief is available on page number 73, running page 73 of the writ petition, the current writ petition.
Mr. Musa, I'm
It is.
sorry, but I don't know, we can't comprehend your arguments, that's all. As to why you're seeking relief here against the new proceeding, when you have a final order from the Manipur High Court, now if you subject
No,
this
no,
proceeding against, that means
my-
you're opening the whole thing
order.
and making the order Manipur redundant, which is judicial
No,
order.
The Manipur High Court, my lord, I had only sought an enforcement of my right under 110(2). 110(2) of the Customs Act is only a proceeding before the adjudication. Now, once the adjudication is complete, my rights under 110(2) of Customs Act becomes frustrated. That is precisely my relief before the Manipur High Court. Page number, I produced the entire pleadings on record, my lord. Page number 73.
That
of
is
the
why
writ
you seek a relief there than that High Court where you already sought relief earlier. That is what this court is saying. That's all. Like, you can't expect two, high courts,
lord,
different
the-
jurisdictions
if I
to
make
deal
that
the same
argument, my
matter
lord.
in piecemeal.
If I
110,
make
2,
this
110, 1
argument,
at Customs Act.
My lord, if I make this argument there, they'll say that the rights under 110(2) have merged with the impugned order here. 110(2), my lord.
I'm afraid you will have to. You'll have to rethink your strategy.
My lord, if I may take your lordship to 100.
Alice,
110.
it can be very much simplified, my lord. Same seizure. For one cause of action, they approach Manipur High Court, my lord.
Exactly, the
My
court's well aware of that.
Right.
Now, we were not aware last time that this order was there. And this order is final.
We have filed a review petition, my lord. Department has filed a review petition. That's
Fine, it's final.
My-
As it stands today, it's final. The thing is that why is he against sealing the proceedings which have been issued by you under 100? Why again? That's the only thing. When if he has to go to Manipur High Court,
has to go to-
why should this court exercise jurisdiction? Simple as that.
My lord, that is because it was. I explain, my lord. Because the commissioner sits in Shillong. Because the commissioner who passed the order sits in Shillong, I had to file it there. The earlier petition had to be filed there because the seizure happened in Manipur. Because now there is no with the impugned order. I can cite authorities before your lordship, wherein if a final adjudication order is passed, then my rights under 110(2) are taken away. It's only a summary right which does not affect the adjudication at all. Now, my case here is that, my lord, the order was issued in haste in order to frustrate my rights under 110(2). And this was done by someone in Shillong, a government officer in Shillong.
My lord, this
That's
honorable
why
court is held otherwise, my lord. What my friend is submitting, to do some more research, this honorable court has held differently, my lord. That 110(2) has nothing to do with the subsequent adjudication
the
proceedings.
adjudication order. If I make this
102 only
argument, my
deals with
friend
the
is
delay serving a notice, that's all. Within
Within
6 months.
6 months, my lord.
Yes.
If I may submit,
And that is a
your
good
lordship
spirit.
may give me one hearing. I shall conclude the personal hearing before the concerned adjudicating authority in 2 days. 2 days time that your lordship is.
Mr. Musa, you make up your mind. Otherwise, next date we're dismissing this matter.
That may not be, my lord.
Yes.
My lord, I can submit authorities. I can submit authorities on the point.
We don't want to embark on a futile exercise. That's all. We'll give you one more opportunity.
The cost of action there. In fact,
We're not convinced. We're not convinced. We're not convinced. We'll give you an opportunity for hearing now.
Yes, one more opportunity.
Yes.
One more opportunity.
You rethink your strategy. Yes, pursuant to the order dated 4/2/2025, the learned DSGI has apprised the court that with regard to the order dated 23/7/2024, passed in WPC number 766/2023 by the Manipur High Court, a review petition has since been preferred. Stop. Next para Mr. Haris Musa for the petitioner on the queries raised by the court with regard to jurisdiction has prayed to be allowed some time. Has prayed that the matter be taken up next date. Only this is matter for 2 weeks. Yes.
Any mention?
My lord, yesterday one matter is fixed on 4th of March, my lord. That is a central bonded warehouse matter. I'm
Yes,
led,
yes.
I'm led by Mr. Misra, Senior Counsel, my lord, and I have taken the consent of Advocate General for listing that instead of 4th on 6th, my lord.
On 6. You've given a mention memo?
I'm giving, my lord. I have taken the
6
consent
is
of
which date? Is it Thursday?
Thursday.
Not a Friday, yes. Yes. Yes.
Deep.
Yes.
Please, Your Lordship. I beg to mention item number 23 and 24 Connecticut matters, my lord. I have to take instruction from my client, my lord.
23, 24 is?
Regarding salary and pension of the staff of District Council.
Now I saw they got a few crores.
40 crores,
I
Your
have to
Lordship.
take
Must be paid now.
I'll
You
take
have
instruction.
now? No.
No, as per instruction, they've got only till August of 2024, my lord.
2008?
August of 2024.
Okay, yes, after 3 weeks.
Apply, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 28.
Yes.
No objection, Your Lordship.
2 weeks.
Yes, Your Lordship.
Yes.
Obliged, Your Lordship.
Yes, yes.
I humbly beg to mention item number 27, my lord.
Who's for the petitioner? 27, Mr. Jindal.
My lord.
Your Lordship, no objection.
My lord, I'm for respondent 3 and 4, my lord. I humbly pray for 2 weeks' time, my lord.
Why?
My lord,
No urgency.
No, Your Lordship.
seeking a
2 weeks.
completion, my lord.
Much will-
Deeply obliged, my lord.
Your Lordship, I beg to mention item number 30, Your Lordship. Your Lordship, let it be after 1 week, Your
Where's
Lordship.
Mr. Sheikh? Your father? Where's the
For the
petitioner?
GHADC, Your Lordship. Item 30, yes, sir.
No objection. No urgency.
No answer.
Yes.
Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 29.
Who's for the petitioner?
Yes, Your Lordship.
You have objection?
Let this matter come next week, Lordship, since it's a gratuity matter, Lordship.
After 1 week?
Yes, Lordship. Hello, Lordship.
Follow.
Supplementary list, item number 1.
Lordship, this pertains to a VC matter, Lordship. Lordship,
VC matter?
VC.
Yes.
Lordship, there are certain discrepancies in the voter list, Lordship.
What is your prayer?
My prayer is to direct the respondents to correct the discrepancies.
What discrepancies?
There are some discrepancies in the among the job card holders in the VC.
Who are
Lordship.
you?
I'm one of the job card holder. I'm a resident of Sobri village, Lordship. Lordship, there's another matter which is pending before this court, Lordship. And they have prayed for similar relief.
So no, why ask the discrepancies? The elections are...
No, election
Are
has
you-
been stayed. Election has been stayed by this honorable court, Lordship.
Same VC?
Same VC. Lordship, can
Then
you
why
come
have you come with the second one then?
No, Lordship, this is only
You
to
can
correct the
impede yourself to the
discrepancies.
other one.
Lordship,
Once you impede yourself the other pending one then?
Yes, my lord, they could have done
Lordship,
Why filing a fresh petition?
Lordship, in those matters, the discrepancies are in with different job card holders, Lordship. Here, there are different job card holders.
Even then you can impede yourself.
Lordship, it can be tagged together, Lordship. Then.
I don't understand. You also, are there discrepancies regarding job card holders?
Job card holders.
Same
Lordship.
matter.
Same,
same
Lordship.
matter, my lord, same pertaining to the same village.
Lordship, we can come together, Lordship. Then. I
Why-
filed my
are you-
representation.
Are you supporting the other case?
Lordship, in fact, no, Lordship.
Then?
Lordship, so far as the other case is concerned, the job card holders, the names of the job card holders are different. Here, in my case, is different, Lordship.
No. Are you supporting that case or you're against it?
No, I'm supporting that case because it's almost similar relief, Lordship, to correct its discrepancies in the job card laws.
Then the thing is that the court can widen the scope, ask for the correction of all the
Lordship, we
discrepancies.
can tag together then, Lordship.
Heard Mr. Eman Nongpur, no counsel petitioner, Mr. Ensign Kwan, Learned counsel accept notice on behalf of
All the
respondents. No further notice called for. Stop. It is submitted by the council that. What's the other WPC pending?
248 of 2024.
WPC 248 on the same subject matter. Yes.
Lordship, in that matter, we have filed a verification for all the voter lists, for all the job card holders.
Okay, please record this, Tom. No? Seems like matter involving verification of job card holders is pending before this court. Stop. Next by M. Talau, correct?
Yes, Lordship.
Appearing petitioner in the set WPC number 248 has also apprised the court that the correction in the set that the relief that the what do you say? Yes, no.
Your Honor, we have filed the verification for all the job card holders in that.
Yeah, for the petitioner there.
Yes, Lordship, in that.
I submitted that in the WPC so and so. Verification is for all the job card holders of what's this place called?
Sobribari, Lordship. Sobribari.
VEC. Stop. Next, we did me. This is matter together with 248 on the next date.
Lordship.
I will look at redundant.
Okay.
Item number 2.
Yes.
Number?
Telestar.
Which one?
Telstar or Telestar?
Telestar. No, not this one. Supplementary. This matter pertains to reservation for Group C and Group D post in the government undertakings.
Yes.
So in this case, it is SBI. If your Lordships kindly have page 184. Annexus 7, 184.
Yes.
Oh, sorry, my lord. Your Lordships may kindly have page 180. Annexus 6.
Yes.
This is, my lord, an OM dated 5th of July 2005, my lord. If your Lordships kindly see this subject, it reads, my lord, revision of quantum of reservation for scheduled caste, scheduled tribe and other backward classes in case of direct recruitment to Group C and Group D post,
yes,
normally attracting candidates for a locality or a region. So the object, my lord, of the OM is to attract local candidates, my lord.
Right, then.
So, my lord, if your Lordships kindly see the next page 181 at serial number 3. So, my lord, it is forwarded to the Department of Economic Affairs in bracket Banking Division. So this is in relation to banking. And then if your Lordships kindly have page 182. So this is the reservation on the basis of population of the scheduled tribe, scheduled caste and OBC. So serial number 17 is my lord Meghalaya, my lord.
Yeah.
So since we are raising the issue with respect to scheduled tribes, your Lordships will see 44% is reserved for scheduled tribes.
In Group C and D post.
Yes, my lord. Now what had happened, my lord? Now this is an OM, my lord. And then, my lord, in 2007, at page 184, the same has been extended to Goa also, my lord. This is again an OM.
Okay.
Now, my lord, the Government of India, my lord, the Union has prepared a compendium, my lord. If your Lordships kindly have page 29 and Annexure 4.
29.
Yes, my lord. Page 29 and Annexure 4, my lord. So this compendium was updated on 14th of October 2022. Your Lordships will kindly have the next page at 30.
Yes.
Serial number 2, reservation in direct recruitment in Group C and D, attracting local candidates. So it is to attract local candidates.
Okay, yes.
Serial number 17, 44%. Now nowhere in this compendium alert, it provides that other scheduled tribes from other states can come and apply. Now again in 2024, my lord, at page 108,
this was maintained.
Yes, my lord, was revised on 28th of March 2024, my lord.
Yeah.
Here again, my lord, at page 109, Meghalaya is there at serial number 17, 44%, based on the population of the tribals. So, my lord, now again in this OAM also, nowhere it provides that candidates from other states can come and apply.
For scheduled castes and direct recruitment, normally attracting candidates means?
Yes, my lord. Yes, my lord.
Normally attracting means like does not bar outside candidate. Normally means?
That is the clarity which we require from the union, my lord.
Yes.
Because what had happened, my lord, one of the petitioners, my lord, at page 186, my lord, page 186,
yes,
annexure 8, had made a representation, my lord, to the bank, seeking for clarity.
He is a candidate.
My lord, candidate is petitioner number 1. This is a, my lord, NGO.
Yes, then what happened?
Now, my lord, then at page 189 annexure 9, the SBI has given a reply.
Page?
189.
Yes.
If your lordships kindly have paragraph number 2, they say, my lord, that the bank is following the instructions, guidelines issued by the Government of India in respect of reservation for SC, ST, OBC category in recruitment employment in the bank, as per the guidelines circulated in DOPT, white brochure. They say brochure. They don't talk about OM, they don't talk about notifications, they talk about a brochure on reservation of SC, ST, OBC in service. It is provided that in case of recruitment on local, regional, zonal, circle basis, SC, ST, OBC candidates not belonging to the concerned locality, so and so, shall also be eligible to get the benefit of reservation. This is what they have replied. And, my lord, they have enclosed, my lord, subsequently again at 192, they again say the same thing, my lord. And they have enclosed this, a few pages of the brochure. Your lordships kindly have page 195. So, it starts from 193, my lord, chapter 2. And at 195, in the middle of the page, your lordships will kindly see note 2.
Yes.
In case of recruitment on local, regional, zonal, circle basis, SC, ST, OBC candidate not belonging to concerned locality, region, state, zone, circle shall
So
also be eligible.
That, for these group C and D posts, all from all over the country, they
Yes,
come
my
and
lord.
apply.
My lord, yes. So my submission is, my lord, if that is the case, my lord, then they could have maintained the 7.5% for ST all over the country. Why have 44% based on population and then bring people from outside, my lord? So we require clarity on this, my lord.
Yes,
So, my lord,
preparing for the state bank.
my lord, notice.
I for the state, your lordship. Respondent number 2.
Interesting point, yes.
Notice will have to be
In the
issued.
sense that why was a memorandum issued with regard to state-wise reservation, like a proportion?
There are two aspects, madam.
Yes.
Lordship has seen 44, 5 and 1%. So
Yes.
cap of 50% is maintained by the government in terms of the various judgment of the Supreme Court. State has exceeded 50%, madam, but union, in my humble submission, cannot exceed 50%.
No, state that's different, yes, but that's been upheld, yes.
Now, second aspect is that central government does not maintain any tribal list of STs. Unlike OBC or state recognizes all scheduled tribes recognized by the state. So in that view, the matter is for center now to segregate between tribes of particular state.
No, but a present proclamation is there, so simple for every state.
For example, there is a vacancy in Delhi.
Yes.
So all these scheduled tribes,
all of India can apply.
All over India can apply.
Now, what is the
objective?
Why should it engage exercise of of saying that okay, fine, 44% here, there are no OBCs here, 1 for OBC, scheduled caste 1. Why? That means that it's meaningless. You might as well say that what he has submitted is correct. I mean, if you're maintaining that that national that reservation policy of 7.5 as an all institutional, maintain that only. You do your memorandum, recall them. It serves no purpose.
My humble submission, 44% has been given to them. Now, the only intention is to bar outsiders.
No, why have they made it state-wise then? What is the practice of other states? Other states is open to everyone.
Open to everyone. Because center does not have any settled tribes list.
No. Whatever it is, then if they have made this sort of a roster kind of situation, then why see the reservation direct recruitment group C and D attracting local candidates. See, that's what they say in the 109. Reservation of scheduled caste and tribes direct recruitment to groups in both normally attracting candidates local was fixed on the basis of proportion of population respective trade duties, and so that is why they reiterate the memorandum 2005 2007, and so like Andhra Pradesh, okay, they put scheduled tribe only 7. Madhya Pradesh 20, Arunachal Pradesh, okay, they put 45, same. Mizoram 45 to maintain that 50%.
There has to be an object to it.
Yes, an object. You can't just make an empty kind of memorandum. And if they want to go by President's proclamation, is there which is a tribe, which is a caste in every state.
Because only when a central entity is advertising the post, they cannot segregate.
Then withdraw this memorandum. You have a option. Yes, heard Mr. Nobody will counsel the petition issue notice. Dr. N.P.F. Union first. Yes, Dr. M. Khan's DSGI was also present, except was the number 1. The respond number 2, Mr. Andy Shriver, AG also is present, except on number 2. Number 3, notice to go to. On number 3 within 3 days. The question involved in the present petition is with regard to the office memorandums which have been issued from time to time with regard to the quantum of reservation to be adopted in different states for member of scheduled tribes in case of direct recruitment to Group C and Group D posts in the State Bank of India. It has been submitted by the Learned Council that there is no clarity in the method and manner in which these vacancies are being filled up. As the point raised is of some importance, then GSGI is instructed to come instruction within 4 weeks time. Yes, it's up to 4 weeks.
One correction, my lord. In the course title, serial number 2, State of Meghalaya, I've just written State of Meghalaya through the secretary. It should be Chief Secretary. So permit me to kindly add.
Yes, Mr. Clements also permitted to make a correction to the nomenclature of the respond number 2.
Item number 3.
Apply your law.
May we please, Your Lordship. This is a case whereby only the age relaxation I'm praying for, Your Lordship. The petitioner here, he is working for last almost 9 years as a lecturer in Tura Government College in the Department of Geography. Then what happened, Your Lordship, throughout there was no advertisement coming. He kept on writing to the government to regularize or to face any interview. He was appointed under 3F.
When is he appointed?
In 2016.
2016.
Under 3F, he was continuing in a regular post on the expiry of the...
I guess sanctioned post, you mean?
Yes, sanctioned post.
Yes, 2016. Now what happened now?
Now what happened? Now on 23rd January 2025, Annexure 8, page 25, Your Lordship, they have advertised a post. At page 25, if Your Lordship is to see.
Yes.
Lordship, at the page 26 at serial 9, the post is Assistant Professor Lecturer in Geography.
Page 26.
26, next is in the reverse. Then, Your Lordship, what happened? There is a discrimination cost. Your Lordship will see at page 27, para 3, age and relaxation. Page 27, Your Lordship has seen that.
3.
27. Yes. Age and relaxation, your upper age limit is 32, as on 1/1/25, with usual relaxation of 5 years for SC, ST. So, Your Lordship, now clause 2, for those candidates who have already applied for the post of lecturer, assistant professor in history, through the MPSC advertisement number 7, 10 February 2020, the upper age limit would be protected. But there was no advertisement for the post of geography in this advertisement, 10 February 2023. And there for the history department, they are saying the upper age limit will be protected. But in geography, no charge. So this is a discrimination, Your Lordship. And I am over by 1 month, 4 days, Your Lordship.
How old are you?
Oh, now only as on 1/1/25, I'll be 1 month, 4 days old.
Yes.
So just, and the last date is on 27, Your Lordship.
He has exceeded by 1 month, 4 days, although he was appointed
But then
under...
you're never regular, you're in government service.
Yes, by 3F.
Under 3F. Under 3F. So
But
I want to...
clarification on what is this for those candidates who applied for the post lecturer history?
History, they are giving the relaxation apparatus. Why not geography?
Meaning that if they were of age at that point of time,
No,
I mean,
yes.
it will not be considered
That
because they
clarity we
re-advertise the
have
post,
to-
you mean. History is here again.
History is there again.
Okay.
What?
History,
History is there,
number
Lordship.
6.
Yes. So the discrimination is caused. Therefore, if can be disposed of.
Council with, will record Mr. Khilab's name.
Yes.
Your bar council registration is still alive. With Mr. Khilab for the petitioner, issue notice MSD Yangi with notary is present except notice on behalf of the respondent number 1, 2, and 3.
All
Notice
4, Your
to issue
Lordship.
to the respondent
Oh,
number
1,
4
2, 3.
within 2 days. Yes. When's the last date of submission?
27, Your Lordship.
27th of March.
Day after tomorrow, Your Lordship. March or February?
No, this month.
February, then why you come so late?
So late.
So late actually what happened, he approached to the government, but they assured this thing they will do corrigendum, they will issue, but didn't issue. That's the reason.
Let's take down the grievance or writ petitioner is that though he has been grievance writ petitioner is that the respondent number 4 by an advertisement dated 23/1/2025 has made no provision for candidates who are already in service, albeit under 3F, whereas no age limit has been prescribed for candidates already in regular government service, and that the upper age limit for applicants, candidates who are post lecturer or post in history through an advertisement dated 10 February 2023 has been protected. Stop. It is submitted that the writ petitioner was just 1 year and 1 month.
1 month, 4 days.
1 month, 4 days.
1 month, 4 days.
1 month, 4 days.
Due to this criteria has been debarred from applying for the post, though serving against a sanctioned post since 2016.
In geography.
Yes, in the Department of Geography. Next paragraph, Ms. Tiangi. When can you come instructions tomorrow?
We have to, Your Lordship.
I'm sorry for that.
Yes, to apprise this court by 26 if possible.
The
MPSC because the MPSC
we stop by dusty service today
to effect dusty service upon respondent number 4 by today. If this is the matter on 27th morning, 27th. Yes. In the motion column.
26,
otherwise,
it can be by tomorrow.
Tomorrow 26, Mr. Mantha.
Tomorrow.
They'll not get it.
No, I'll stop today itself.
You've come too late. You know, you should have come a little earlier because these kind of cases with 1
Anyway,
month.
it's all right. Much
This
obliged.
link was open from the 7th of February, Your Lordship.
No, he approached,
All this
of course,
time
of
we
the
were-
court, he approached the minister as you to issue corrigendum.
Approach you just yesterday.
No,
Item number 1.
Friday. Yeah, I'm so sorry. Much obliged. Much obliged.
My Lord, this matter relates to
1 and accident number 2021.
1, 20, 21.
1?
2021.
Well,
20, I'm appearing for the petitioner, my lord.
What of you out, no? Man Kasia and you're out also.
yeah, I'm selected, my lord.
Yeah? Oh yeah, sorry.
Yes.
You are in Meghalaya roofing.
Right.
Okay, one second. Meg roofing. Then you're appealing for power roofing. Power roofing. Power isn't WER.
Yes, POWER, power roofing. These two were selected.
Then, okay. And those two people are out?
I'm for Miriam Commerce. Item
are
number
out.
21. Miriam Commerce.
And
I'm from Manaxia.
Manaxia.
My lord, in item 21, they have not filed, the government has not filed its affidavit.
The affidavit filed in that will cover your lordship.
File where?
No, my lord, because I was disqualified on a different ground, my lord. In my matter, they filed the affidavit on 19th, which are required to file a rejoinder, short rejoinder.
But this is a Roti Kapra Makan case.
Yes, ma'am.
Minus 20 and in item number 20, I have filed an application for vacating under 226 3 months.
When's expiring? Today?
In my submission, this is already expired.
See, it expires if the court doesn't take it up at all. That is judgments that say. You want another judgment?
I have case laws, madam.
Even if it's taken up also and not decided, it will vacate by itself.
By operation of law. Of course, that does not preclude this honorable court to re-hear the matter. If the file a fresh application, grant another stay.
That is judgment.
19 is when? 19 was?
19 was last.
Now it's 25th.
Wednesday, my lord.
But what I am praying, if the matter is heard today, my lord, at least my vacating, they file a reply also. If item number 20 is heard first, my lord, that depending on the outcome, then Mr. Sangresu's case will become.
Mr. Changreso has his own grievance. Why should you
I have
take
my
the lion's
case
share?
also. Yes.
And he gets only the peanuts?
Yes.
And my grievances
Madam,
also.
stay over stays.
No, the thing is that, see, Dr. Mozika, one thing is, if they have alleged, there's some discrimination, infringing upon a commercial matter, no doubt. But even then,
That also
Mr. Shulai has to tell us why has he done this 75-25?
Yes, sir. Yes, sir.
That's for Mr. Shulai to satisfy.
Yes,
For you, just a beneficiary. In fact, for you, don't have anything to say.
Right.
I can still
Exactly. State has to justify its action. That's the core issue. Core issue.
Yeah, but then you can cite the rules, of course, but you have cite rule only. The main rule is by Mr. Shulai. He is the owner of the contract.
Lordship, kindly see the Lordship,
Let's take up which matter we'll take up first.
Yes.
Well, Lordship takes up item number 20 first.
What about he wants to file rejoinder to what?
To the counter filed by the state.
What's the
Well,
state's-
there also I'm a party.
Have
I'm
you
yet to receive.
Because, my lord,
justified there your 75-25 in the affidavit?
Lordship, we have filed, yes.
Have you justified it there? Why you have given 75 to?
No, not in his
Why?
matter, Lordship. In his matter, Lordship. Against that, because he does not fulfill the criteria laid down in the NIT,
In the
Lordship.
affidavit, they have said that they have gone by the terms, strictly by the terms and conditions of the NIQ. Now, if your lordships remember in the first round, the main contention was that Invest Meghalaya. If your lordships recollect, Invest Meghalaya, the certificate of Invest Meghalaya. Now, in this case, my lord, they have filed the copy of the minutes. There's no discussion about Invest Meghalaya because none of the parties have Invest Meghalaya. They have not even discussed or relaxed it also. So technically, my lord, everyone is disqualified if they go strictly by the terms of the NIQ. So this tender process has to be set aside.
He does not have, your Lordship,
We have, my lord.
the trading license. Lordship, instead of gold deposit, he submitted a fixed deposit, your Lordship, which is not the condition laid down in the NIT, your Lordship.
But I'll please, because I'm the applicant, my lord, 226.3. Lordship permits, I'll
Okay,
place
let's just hear. Okay,
item number 20.
let's hear the matter for vacating. This case number?
Miss case number 15, 15.
Okay, yes.
So, my lord, Your Lordship kindly takes up WBC 478, the connected writ petition, my lord, in this matter. 478.
Okay. Manaksya.
Manaksya.
Yes.
My lord, page 16, annexure 2 is the NIT, my lord.
Page
16. It starts, my lord, page 16. I'll take Your Lordship to 19, my lord, page 19.
Yes.
My lord, somewhere in the middle, my lord, clause B, technical bid.
Yes.
Then it says, my lord, technical bid quotation must be in the prescribed format in annexure 1 and 2, enclosing the following documents, without which technical bid shall be summarily rejected. Then clause 2, my lord.
Yes.
This is where the entire case rests. Earnest money deposit in the form of call deposit, bank draft or demand draft, drawn on any nationalized bank payable at Shillong, placed in favor of Directorate of Housing, Meghalaya, Shillong. So, one of the requirement was call deposit,
yes,
bank draft or demand draft.
Yes. Yes.
My lord, what petitioner submitted, my lord, at page 79, Your Lordship kindly comes.
Authorized petition?
Yes, my lord.
Fixed deposit QIP.
My lord, on the top it says, my lord, deposit confirmation advice.
What is it? Deposit?
Page 79, my lord.
Okay, this is deposit confirmation. Okay.
Deposit
The
confirmation
seal is on top,
advice.
yes.
Now, my lord, if Lordship kindly comes towards the bottom, my lord, there are some notes in this. Clause number, my lord, one thing important, my lord, kindly see the amount, my lord, here. The amount is 1,39,30,000 rupees, my lord. In a table in the middle, my lord, on the right hand portion, my lord. Maturity value, Lordship saying.
Yes.
1,39,00,000 rupees, my lord.
How can it be the same amount? Deposit amount 1,39 lakhs.
Maturity value is also same, my lord.
How? You deposit 7.15 at 2024 to 26.
Now, my lord, in the same document towards the bottom, my lord, at serial number 6, your lords will see premature withdrawal clause.
Yes.
It says, my lord, premature withdrawal of deposit less than rupees 1 crore will attract 1% penalty, that is 1% less than the card rate as on the date of deposit for the period for which deposit has remained with bank. Now, then, my lord, premature withdrawal of deposit of rupees 1 crore and above will attract 1.5% penalty, that is 1.5% less than card rate on the date of deposit for the period for which deposit has remained with the bank. Then it says, my lord, for premature withdrawal of deposit rupees 1 crore and above, a withdrawal notice minimum 31 days prior to withdrawal to deposit is to be given to the bank. Then it says, my lord, in case of non-collegible deposit, premature withdrawal not allowed. My lord, this is what they submit on the closing date of the NIT, my lord.
Is made in whose favor?
It is made in their favor, my lord.
Favor of that housing?
No, my lord, Manaksha Albuni Company Limited.
What beneficiary written there on top?
They pledged, it seems, my lord, beneficiary Director of Housing Meghalaya, but this advice is issued in favor of Manaksha Albuni, my lord. Now, my lord, what is critical here? That this is not incassable immediately, my lord. 31 days notice is required. Lots of you seen that.
Yes.
Plus, there are penalty clauses. And then it says, my lord, at serial number 7, in case of non-callable deposit, premature withdrawal not allowed at all. Now, my lord, this document nowhere says whether it is callable deposit or it is not is a non-callable deposit, my lord. Nowhere. I've tried to read each and every word of this paper, my lord. It doesn't mention anywhere, my lord. Now, my lord, the last date of submission of bids was 15th of October 24. What they do, my lord, as an afterthought, they bring a letter from bank that is in the next page, my lord. Page 80. Now, this they bring after the closing date of the NIT, my lord. What it says, my lord, the manager, Meenakshi Aluminium Company Limited, reference your letter. They seek clarification, my lord, dated 9/10/24 for deposit account number so and so for 1,39 so and so. Clarification of premature withdrawal of deposit amount. This is to confirm that deposit account number so and so is placed in the name of beneficiary director of housing so and so on 9/10/24 for a period of 25 months, valid till 9/11/26 by Meenakshi Aluminium Company Limited. Upon request from Meenakshi Company Limited. Now, my lord, kindly note these words. It is hereby clarified that if our bank gets any written instruction from the beneficiary of deposit, that is Director of Housing Meghalaya Shillong, at any date between 9/10 and 9/11/26, then we shall release the fund of rupees 1,39 lakh in the name of the Director of Housing. Also, it is clarified that once a deposit is placed in the name of a third party, then the same becomes a call deposit, which can be matured at any time upon the request of beneficiary. Hence, this deposit is a form of call deposit placed in the name of beneficiary, that is Director of Housing. Now, my lord, in this letter, number one, this is issued at the behest of the depositor, my lord, number one. Secondly, it is submitted after the closing date of the NIT, my lord.
When was the NIT closed?
15th October, my lord.
15 October?
My lord. This itself is issued on 21st October, my lord.
10th October?
Lordship, yes.
15th October was the last date, my lord, of submission of bids.
15/10/24, Your Lordship, that was the last date.
Okay.
This clarification itself, Lordship, is seen, issued on 21/10/11/24 after the closing date, my lord. This letter does not state anywhere under which banking regulation, my lord, upon pledging in favor of somebody, a document becomes callable or non-callable, my lord.
Yes.
And this is contrary to what is specifically prescribed, stipulated in the document, my lord. Document says 31 days notice is required, my lord. And there is a penalty on and then it says that if it, in case of non-callable, it is not a withdrawal premature at all.
Yes. Yes.
So, my lord, in this background, my lord, the document submitted by the petitioner, the writ petitioner, was not accepted by the tendering by the state, my lord.
Yes.
Now, my lord, I'll take your lordship to the impugned order.
Passed by this court.
No, my lord. The order they have challenged, my lord, in the writ petition.
In Manakasya?
Writ petition, my lord.
Well, it's only technical bid, it's only.
No, financial bids have been opened.
I mean, at this point when it was filed, it's only technical bid. And they were disqualified at the technical stage, correct?
No, my lord, this was filed after even the financial bids were opened, my lord.
After financial opened, it was filed?
But
Okay.
after, it's okay, let him finish.
Yeah. Yes.
Impugned order page. Page 90, my lord. Annex 17.
Yes.
This is from Directorate of Housing, dated 12th December 24. Meenakshi Aluminium so and so, your letter number so and so. With reference to the subject mentioned above and in response to your reply to notice inviting so and so, under reference I am to furnish you with the following information as sought for. The bidders were found not qualified by the Department Enter Committee Purchased Board Committee are Meenakshi Aluminium Company Limited. No call deposit, bank draft, demand draft submitted as earnest money as stipulated in the NIQ. Trade license submitted is from West Bengal and not from the concerned district as required under clause 13 of the stipulated general term and condition of the NIQ. Second one, Mr. Sila's client, Mariam Commerce, partnership agreement dated 1st August 24 not submitted as declared in the power of attorney document, certificate enclosed. Detailed technical specifications is not mentioned in the catalogs, brochures as required as terms and conditions stipulated at B technical bid clause so and so. Trading license being a partnership firm not submitted from concerned district council. Then it says, qualified bidders are Meghalaya Roofing and Messrs. Power Roofing, and relevant documents can be obtained on filing an application under so and so.
Okay.
So, my lord, on two grounds they are rejected, my lord. One is non-furnishing of trading license from the district council, and the other one is the non-deposit of the EMD in terms of NIC.
Yes, Mr. Nombri.
Now, my lord, when the writ petition was filed, my lord, they referred to the earlier order passed by your lordship. in this matter, where Lordship has said that trading license is inconsequential. Meaning that a trading license will come into picture only if they are successful in the bid, and before executing the contract, I think they'll have to obtain a trading license. But here is a case, my lord, primarily they are rejected on the ground of non-submission of EMD in terms of the NIT, my lord. Now, my lord, this is a welfare project, my lord, for monsoon's purpose. And
we understand, that's why we're thinking of the matter today. Yes, Mr. Nong.
Yes, Lord, kindly have my petition, my lord.
Yes.
The intimation by the government, my lord, if your lordships have page 87. Page 87, annexure 16. This is an email, my lord. In the middle of the page, my lord, from Director, Housing.
Yes.
My lord, dated 10th December 2024. 10th December. What was enclosed is, my lord, the next page, page 88. 4th December. So this communication of 4th December, my lord, was communicated to us only on 10th, and that too, my lord, because of page 86. Page 86. On 9th of December, we wrote to them, my lord, what has happened to our bid, my lord. Page 86. 9th of December. It is then, my lord, on 10th of December, they send the email with a backdate letter of 4th December.
So?
Yes, my lord. Now I'll take your lordships to the counter file by the state, my lord.
478. State 1 to 3.
1 to 3, my lord. Page 17 of your lordships has.
Yes.
Page 17, paragraph 12, if your lordships has. They say, my lord, in reply to the averments made in paragraph 14 of the writ petition, the answering respondent humbly submits that the departmental tender committee, duly constituted by the government to examine and recommend the technical bids, was held on 14th November and 20th November, and approved by the government. My lord, para 12, middle of the page, page 17. Technical bids was held on, examined and recommended the technical bids was held on 14th November and 20th November. And approval by the government of the recommended successful bidders was obtained and initiated on 27th November. So they got the approval on 27th November. They themselves state, my lord, the tendering authority then white letter dated 4th of December, forwarded and intimated the decision of the government to the petitioner. Now I'll take your lordships to the minutes, my lord, which is at page 56. This is very important, my lord. And also that portion, my lord, where Invest Meghalaya was one of the terms and conditions, which they are saying tender documents has to be strictly by the tender terms. It reads, my lord, page 56, annexure 7, proceedings of the departmental tender committee, departmental purchase board meeting of the housing department held on 14th November at 3 p.m. and 20th November at 11 a.m. in the office and chamber of so-and-so. It reads, my lord, at the outset, the chairman of the committee, Shri so-and-so, welcomed and appraised the members present that the departmental tender committee was convened to scrutinize and examine the technical bid documents tendered by the bidders in pursuance to the terms and conditions of the NIQ floated by the tendering authority, white so-and-so, dated 10th December 2024, for supply of aluminium roofing sheets under CMHAP, a scheme of the housing department, Government of Meghalaya. He then requested the director to initiate the discussion. The director housing informed the committee members that during 2024-25 an amount of 70 crores as per budget provision was sanctioned by the government, White sanction number so-and-so, dated 7th of August 2024, for implementation of Chief Minister's Housing Assistance Program, and accordingly the tender was floated on 10th September 2024. And the last date of submission of the tender, the two-bid system, submission of the two-bid system, technical bid and financial bid, was fixed on 15th October. The tender authority opened the technical bids at 3 p.m. after closure of NIQ on 14th October 2024. In presence of the bidder or their representatives, there were 4 number of quotationers, bidders who participated, and the comparative statement duly compiled was enclosed, along with the agenda note supplied to all the members of the Departmental Tender Committee. The chairman then requested all members to pursue the details of the tender and conditions, corrigendum issued, and the NIQ floated as stated above. The comparative statement duly compiled by the tendering authority. Having perused the NIQ, the corrigendums, the comparative statements, etc., and the members minutely examined and scrutinized the technical bid documents, papers, and submitted by each bidder, quotationer, and the finding is as detailed below. So it is on 14th November that this was done. Number 1 minute in the table, Manaksya, views and findings: no call deposit, bank draft, demand draft submitted as earnest money as stipulated in the NIQ. Trading license submitted is from West Bengal and not from the concerned district as required under clause 13 or the stipulated A general term and conditions of the NIQ. Number 2, my lord, Miriam Commerce, number 1 on the right side, my lord, partnership agreement deed so-and-so not submitted as declared. Number 2, detailed technical specification is not mentioned. Number 3, trading license. And the next table, my lord, Messrs Meghalaya Roofing, all supporting documents submitted are in order as per the terms and conditions of the NIQ. Power Roofing, all supporting documents submitted are in order as per the terms and conditions of the NIQ. Then it reads, my lord, however, the Departmental Tender Committee could not examine nor verify the cut size sample sheets of aluminium sheets as submitted by each quotationer, tenderer, bidder, as there was an error in the screw gauge equipment. Hence, the Department Tender Committee was adjourned and reconvened, refixed on 20th November 2024 at 11 a.m. in the office of so-and-so. To verify the same, samples, revisit, re-examine, and other technical issues before finalization of the decisions and recommendations. In pursuance to the decision of the Departmental Tender Committee held on 14th November 2024 above, the Departmental Tender Committee was reconvened on 20th November 2024 after a brief welcome from the chairman to all members and appraisal of the minutes recorded and decisions taken in the last sitting of the committee. The inspection, gauging of all the aluminium sheets as submitted by the bidders were undertaken, and the committee members noted that the samples submitted by all the bidders conform to the specifications prescribed in the NIQ. After thorough deliberation and evaluations of the eligibility criteria in all aspects relating to technical bids, documents, certificates, etc., which were expected to be submitted by concerned bidders who bidded as per the specifications as per specified terms and conditions stipulated in the NIQ, the following were the decisions. Number 1, the committee members recommended Messrs Meghalaya Roofing and Messrs Power Roofing to have qualified the technical bid and are shortlisted for opening of the price bid documents. Number 2, the price bid of Messrs Manaksya Aluminium Company Limited and Messrs Miriam Commerce are to be returned unopened by the tendering authority to the parties concerned. Later, the tendering authority through the Director of Housing informed the Departmental Tender Committee that representatives of both recommended and qualified bidders were intimated and called and expressed their willingness to be present in the opening of the price bid. Same day, my lord, they were called, successful bidders. The committee members therefore authorized the tendering authority to open the price bids documents in the presence of all the members of both the tendering authority, Departmental Tender Committee, and the bidders or the authorized representatives. Now, my lord, after this, something goes missing, and then the next page it suddenly starts with perusal. So I don't know whether it's correct or There's something missing, my lord.
Hmm.
So at page 50.
What's missing, Mr. Shulai? You have the records with you?
Records will have to be called, my lord.
Is that there the reverse page?
No, my lord. So it reads, my lord, perusal and analysis were taken by the tender committee of the price bid documents.
Okay, fine. What else you have
Yes,
to say?
my lord. Then, my lord.
What about it, Invest Meghalaya? Where did you get it from? It's not here. It's not in the minutes.
It's not in the committee. Your lordships will have to come to NIQ, my lord. I'll take your lordships.
No, there's no discussion on that at all.
There's no discussion, my lord. That is what I'm saying, my lord. It is one of the conditions in the NIQ, my lord.
No, but in the technical bid submitted, you have manufacturing facilities in Meghalaya?
Yes, my lord.
They don't.
Not only that, my lord, we are registered under MSME Act and in Meghalaya, my lord.
And what about
they are not registered.
Mr. Changri? So
Not registered.
Also we have.
They are not registered, my lord.
Was that the reason for sending it 25? And they did away with the condition. They should have given 100% to you then. You
My lord,
only one who has
they are a new unit, my lord. They have not started production also, my lord.
In fact, that is our case before the government, my lord. If necessary, we may come up with a rate person, my lord. But I'm not complicating the thing now at this stage, my lord.
Why is the page missing, Mr. Shulai?
No, it's not missing.
It's there.
Yes, a lordship is like this.
You put it on some other page.
And the bidders or the bidders or their then stop. Perusal and analysis were under.
Why it starts with a small p then?
Well, photocopying, I think, few lines from the previous page.
No, it ends there.
Previous page is full stop, my lord.
No, anyway, it's not so material, but even then, but any document presented to the court, any document presented to the court, should be in full and complete form.
Now to proceed further, my lord.
No, let's see that. Where's the Invest Meghalaya NIQ?
Yes, my lord. If your lordships kindly have the NIQ.
Page 20. Where's that?
Page 16, my lord.
This all is the affidavit, sorry.
Of the petition.
Yes. Where's
Page 16, my lord. Your lordships will kindly have page 17, the general conditions, my lord. General terms and conditions. At serial number 6, my lord.
A valid registration, that's all.
Yes, my lord. Of Invest Meghalaya. Now
you say
I had filed a writ.
You say that they don't have that.
They don't have.
That this what's Mr. Dr. Mazika's client's
power roofing, my lord.
They don't have that.
They don't have that.
Don't have registration.
No, my lord, because till date nobody has ever been registered under
this MSME.
Yes, my lord. No certificate has been issued in the state till date. Invest Meghalaya, my lord, under the policy.
That's it. Yes, what
Yes,
shall I have to say?
And I'll just take your lordships to the to your lordships order also, which vacation is being sought, my lord. Just.
You updated.
I do have the application, my lord.
1712.
Miss case number 15.
No, the order is 1712.
Oh, yes, my lord. My lord. Now, my lord, I've shown your lordship that on 10th of December, that email was sent to me, and the order impugned is 12th of December, my lord. Immediately I came before your lordships, and the matter was before your lordships on the 17th, and this order was passed, my lord. So 14th of November they sit for the tender committee, and 20th of November. I have been rejected. I have been informed only after a month, my lord.
What's the 344, don't we see?
344, my lord, is that writ petition wherein I had challenged the NIQ, the terms and conditions, saying restrictive invest Meghalaya, trading license.
Yes. Yes, what do you have to say?
Yes, my lord. May I just read the order, my lord? Just for your lordships to recapitulate, my lord. This is order 17th of December 2024 at page 14. Heard Mrs. So-and-so. Issue notice. Mrs. So-and-so assisted by so-and-so in present and accepted notice. Issue notice to remaining respondents registered ID 3 days. The petitioner is a registered company is before this court assailing the rejection of the bid for supply of roofing sheets which had been floated white NIQ dated 10th of September 2024. Mr. So-and-so learned counsel for the petitioner submits that the bid had been rejected on two grounds. Firstly, that no call deposit bank draft demand draft has been submitted as stipulated in the NIQ. And further, that the trading license submitted was from West Bengal and not from the concerned district as required in clause 13 of the general terms and conditions in the NIQ. The learned counsel has taken this court to the first rejection, that is the unavailability of the call deposit, and has referred to Annexure 13 and 14 of the writ petition to show that the said call deposit had been created in favor of respondent number 3, and as such he submits this clause is satisfied. On the other hand, on the other ground, that is in non-supply of trading license, the learned counsel had referred to orders of this court dated 14th of October 2024, passed in writ petition 344 of 24, wherein this court had observed that trading license is a consequential factor on the bidder being eligible or awarded with the contract. He therefore submits that in the trading license, as per the order of this court, is necessary only when awarded with the contract, and the rejection of the bid of the petitioner on both grounds is therefore unsustainable. It is further submitted that the bid has since been settled with the respondent number 4 and 5 and contends that as the rejection of is arbitrary, he is praised for some interim orders. Mr. So-and-so, learned AG, for the state respondents has strongly contended that the documents which have been annexed in Annexure 13 is not a call deposit, but in fact is a fixed deposit, and further that in the orders of this court, the requirement of production of trading license has not been done away with. He further submits that the bid has been settled with the remaining two tenderers, and as such nothing remains for consideration, and if the petitioner is aggrieved in any manner, he is at liberty to resort to civil remedy. Having heard the learned counsel for the parties and examined the materials as placed, it is seen as submitted that the petitioner has been disqualified as a bidder on two grounds, that is, non-furnishing of call deposit and trading license. It is noted that the documents annexed at Annexure 13, though styled as fixed deposit, may perhaps be taken as a call deposit, which deserves further examination by this court. As also the second ground with regard to the non-furnishing of trading license, as to whether the same should have been offered at the time of bidding itself. As it has been submitted that the bid has been settled, on a further query about the successful bidders, the learned AG has apprised the court that the contract has since been settled with the two remaining bidders, that is respondent number 4 and 5. Out of the 4 bidders, 2 whereof, including the petitioner, had been disqualified. This settlement of bids with respondent 4 and 5, therefore, and is indeed the entire tender process to the mind of this court at this stage, deserves further examination. Examination as to its legality in the manner of award of contracts. In these circumstances, and in consideration thereof, as the matter deserves further examination, and as the scope of the contract is large, involving public interest, wherein any transaction concerning public interest should be transparent, it is considered necessary at this stage that some interim orders are passed. Accordingly, it is ordered that until the next date for award of supply of the award of supply of roofing sheets by respondent number 4 and 5 under the NIQ dated so and so shall remain state. The state respondents to file the affidavit.
Yes, Mr. Shilla. I think you don't need to make your submissions. He's already submitted on your behalf.
Yes,
also.
my lord, I have filed my affidavit also, my lord, and with regard to this application for stay, I'd just like to take my lord to paragraph 6 of my affidavit.
Your case?
No, my lord. In this application which they have filed for stay, my lord, they have implemented me, and I have filed my affidavit also.
Your phone number?
Opposite in the application, my lord, I am for opposite
your
party
phone
number 6. Yes, my lord.
Oh yes, got it. Yes.
Paragraph 6 of my affidavit, my lord. It says that with regard to the statement made in paragraph 4 and paragraph 4A to 4Q of the miscellaneous application, The answering deponent respectfully reiterates that the interim order dated 17/12/2024 passed by this Honourable Court in WPC number 478 of 2024, staying the award or supply of roofing sheets by the applicant and opposite party number 5 pursuant to the notice inviting quotation dated so and so has a direct and material bearing on WPC.
Where are you reading from? Your affidavit?
Yes, my lord. Page 5, paragraph 6, my lord.
Okay. Yes.
I'll read from the beginning.
Yes, yes, yes.
Yes. Your Lordship has it, paragraph 6. Yes. That with regard to the statements made in paragraph 4 and paragraph 4A to 4Q of miscellaneous application, the answering deponent respectfully reiterates that the interim order dated so and so passed by this Honourable Court in WPC number 478 of 2024, staying the award or supply of roofing sheets by the applicant and opposite party number 5 pursuant to the notice inviting quotation dated so and so has a direct and material bearing on WPC number 480 of 2024. That's my WPC, my lord. As both writ petitions challenge the same tender process, it is stated herein that entertaining the present miscellaneous application which seeks the modification, alteration or vacation of the interim order dated so and so without due consideration of WPC number 480 of 2024, wherein Marine Commerce has categorically raised substantial grounds challenging the tender process arising from NIQ dated so and so will result in grave prejudice and injustice to Marine Commerce. Furthermore, it's pertinent to highlight that the applicant and opposite party number 5, having been declared as successful bidders, were awarded the contract at an exorbitantly high rate of so and so per bundle, which is significantly higher than the rate offered by petitioner. This inflated pricing has resulted in an estimated financial loss of approximately around 22 crores to the state exchequer. Consequently, the decision to award the contract at such an excessive rate has led to an unwarranted expenditure of public fund to the detriment of the intended beneficiary. Had the contract been awarded at the lower rate offered by petitioner, a greater number of individuals could have been provided with roofing sheets, thereby ensuring more sufficient and judicious utilization of public resources in furtherance of the public interest. My lord, that's why if this application is to be entertained, my lord.
What is your rate?
My lord,
you don't know.
That's what the client said, around 22 crores. If we go by this rate, my lord, around 22 crores loss would be caused to the state exchequer.
See, you can't make just statements like this.
That,
where's the breakdown?
That is one point which I did not indicate, my lord. The price bid of both the parties exactly same, my lord. A case of price. My lord,
cartelization.
Yes, yes, exactly.
Whatever it is, but then you have to.
My lord, that's why if this.
That means you don't even have the roofing with you.
No, my lord, because while submitting the bid.
What's the market price for roofing material?
My lord, while submitting the bid, we have to also submit the sample.
How many tins? Mr. Shulai, you're expert in construction, no?
I think 9 sheets. 9 sheets.
It depends.
So on the quality. So what gauge did they approve for this supply to this under this scheme? See, different gauges because it's aluminium and steel.
Look at in the tender committee minutes.
Yeah, the gauge. You know what is the gauge thickness?
It must be the NIT is there. That is what has been stated.
When NIT they specify the gauge, the thickness of the sheet.
No, Lordship,
why is this court asking? You see, because the thing is that sometimes the roofing sheet has been supplied to poor people just like paper. When one wind comes, it's torn like.
My lord, so far as that aspect is concerned, my lord, if I may, with your lordship permission, my lord, while submitting the bid, we are also required to submit the samples, my lord.
Where's the sample you brought today?
No. But my lord will see that from what my learned friend has read, the minutes of the tender committee, my lord will see.
You have brought a sample of the tin. It's a small sheet, correct? Not the whole roof.
0.4 mm, 0.45 mm thick.
0.4 mm.
0.45 mm.
My lord, so far as the quality of tin is concerned, my lord, roofing tin, all the participating bidders are required to submit samples. And my lord, so far as the minutes of the tender committee is concerned, although the copy of the affidavit of state is not served upon me, but from what my learned friend has read, my lord, I'm reading from his copy, my lord, it appears that this quality of the sample has also been verified, and all the 4 bidders, and all the quality is found to be in perfect condition, my lord. Satisfactory. And now
not like the Assam Rifles case where samples for those, what's it called?
Like this.
Those camouflage.
Action can be taken against us, but my lord, so far as the expert.
What was submitted as sample and what was given to the troops Two different.
No, my lord, action can be taken against us.
Prominent instead of camouflaging them.
But my lord, so far as the expert opinion is concerned, that this is the government own opinion, my lord. This is not our opinion, but it's the opinion of the government. But these samples.
What is your rate? 0.45 mm gauge. What is the market rate?
My lord, for that I have to take
You should have
instruction.
come with those facts in your fingertips if you want to show that that the rate given to them is arbitrary.
But from what my client has told me, my lord, around 22 crores.
No, that's fine. And you can even Mr. Dr. Mohammed can make same thing that quote that the state by a metal so good they're making a saving of 50 crores. Who was to say sitting here?
I can file an affidavit to bring this facts on record, my lord. And
too far in the day, too late in the day.
My lord, and that apart, my lord, that apart, this particular contract, my lord, it's not only confined to this amount.
No, your rejection is on some power
Yes,
attorney.
my lord.
What is that?
If my lord permits me, I can open my case, my lord. I present my case.
No, power attorney. What power attorney do you give?
My lord, I'm rejected
only
on
that
three
point. On your rejection.
Yes, my lord.
Yes,
So far as
not on the other aspect.
Yes, my lord. So far as my case, so far
exchequer
yes.
or gain, that is not.
My lord, so far as my case is concerned, my lord, I have been rejected on 3 grounds.
Why did you not submit your partnership documents?
Because, my lord, the tender document itself, the NIQ itself, does not require for us to submit our power of partnership deed. I will take my lord to that. What are the documents that is required to be submitted? It's categorically mentioned in the NIQ. My lord, for that, my lord, I have to take
the NIQ again.
Yes. My lord, I have to take my lord to my writ petition then, my lord.
Yes. What's the petition?
My writ petition 480.
Because it is a pointed rejection, and the thing is that if then you'll have to resort to other remedies. But see, there's one thing, Mr. Shilai, you must remember that this court is not sitting in appeal.
Exactly, my lord. Exactly, my lord. My lord.
We're just sitting. It's just like we just bring whether any of your rights have been violated, whether the action of the tender company is just beyond that is it's shocking to the normal mind, or they have exceeded so it has to be you can discern it from the records, but then we can't go nitty-gritty
Yes. My lord, I bow down to that, my lord. My lord, my only case is this, my lord.
You might have a very good case.
Yes.
My thing is that if it's not presented in the fact not presented, this court's helpless.
My lord, I bow down to that, my lord. My only endeavor is to impress upon this honorable court that my bid has been arbitrarily rejected, my lord. In spite of having all the requirements, my bid has been rejected.
Where's
my
that?
lord, page 44, my lord, of page 44 of my writ petition. Page 44, my lord.
44, sorry. Yes. Where's that thing? Where's that power to him?
My lord, no, my lord. This is the NIQ, my lord. I'm taking my lord to the NIQ. My lord, technical bit B, my lord. These are the documents required, my lord. Technical bid quotation must be prescribed.
What do you submit? Where's the power attorney you submitted?
There's nothing mentioned, my lord, here of the requirement of
power attorney, board resolution, original copy authority to send a tender. Because you have tendered as a firm.
Power of attorney is there, my lord, but partnership deed is not. They are not rejected me on the ground of power of attorney.
Where's the power attorney? Page? Let's not waste much time. What is Tunum roof?
Page, power of attorney is page, is page 37, my lord. Page 37, my lord.
Now, where's the now this partnership is constituted of whom? By whom?
My lord, initially it's constituted of 2 persons. One person's retired, and then we are left with the petitioner.
Where's that document? Who's this Tribok Kurba?
She subsequently added, my lord. The original partnership deed is in Annexure 1, page 19.
Annexure 1?
Yes, my lord, page 19. Initially, there were 2 partners, my lord, Shri Vijay Kumar Goyal and Shri Gilbert Dingda.
2 of them?
Yes, my lord. And then subsequently, this person, Vijay Goyal, retired, my lord, and
is that?
Srimati Tribok Kurba was added. That is in page 26, my lord.
You submitted all these documents before you submitted before the bids were closed.
No, my lord. So far as, because my lord, that's why I'll take my lord to the
See,
NIQ.
Mr. Shilla, like whatever has to be on record before tender committee must be as on 10. What's that? 5/10. 15/10. Sorry, 15/10/2024. Finish. Period. That's all.
But my lord, if I may,
That's all that we have to.
if
If
I may
you
be
can't allow them after the tender process, after the bids are closed, you can't keep on submitting documents. Then you can cure any defect.
If I may be permitted, my lord.
I'm permitting you full. I mean, permission's been given.
Yes, my lord.
Yes.
My lord, I'm just trying
But
to.
you just be clear.
Yes, my lord.
These documents which you have submitted were there before the tender committee. That's all.
My lord, for that, my lord, my endeavor is to place before this honorable court what are the documents that is required under NIQ to be submitted for technical bid. For that, my lord will see the NIQ itself at page
See, if
44.
your partnership deed it says Vijay Kumar Goyal, then how can this other person, Tribok or whatever, give you authority power to?
No, because subsequently he retired, my lord, and then.
No, but then that's not the knowledge of the tender committee.
My lord, I'll just take.
I don't want to argue with the councils, but just like you have to be clear to the facts.
Yes. My lord, I'll just take my lord to the NIQ, my lord.
Yes, we are the NIQ, page 44.
Page 44.
Yes.
Technical bid B, my lord. It says here, technical bid quotation must be in prescribed format annexure 1 and 2, including the following documents, without which technical bid shall be summarily rejected. Number 1, tender fee. Number 2, earnest money deposit in the form of so and so. Number
You submitted call deposit.
Yes, my lord.
Okay,
I'm not
very
rejected
good.
on that ground, my lord. Number 3, power of attorney, board resolution, original copy, authorizing the signatory to sign the tender document on behalf of the bidder. The power of attorney, board resolution will be specifically for this tender only. Power of attorney is there, my lord. Number 3, attested passport size is there. 5, attested copy of SCST is there, my lord. 6, attested copy of valid GST certificate is there. 7, attested copy of PAN card, that is there, my lord. 8, non-tribal quotationer should face trading license. That I have not submitted, my lord.
Why?
Because, my lord, there is a office memorandum of the government itself which says that only if you are successful bidder, then only the question of non-tribal submitting tribal.
You're a local non-tribal entity, you have to have tribal license.
Partnership deed, my lord. All the partners here are
All
tribals.
partnerships are non-tribals. Any partnership income tax act does not have anything. That has been a subject of
yes, my lord.
like a lot of litigation.
Yes, but that apart, my lord, there
that
is
commission is not acceptable.
But that apart, my lord, the government itself has its own office memorandum. I'll place it, my lord, which says that only after you become.
Given to tender committee before.
Yes, my lord.
Was it placed for tender committee?
No, my lord, because there is this order of this honorable court also, which says that trading license is consequential of being successful, my lord. The order of this honorable court.
That is in the context of, what has happened, why that order was passed, why we said we'll delve into it further, is that when outstation firms come and compete, okay? Now, if you're a local firm, it'll be different. But if outstation firms come compete, now they're not sure of getting the contract at all. And so suppose everything's remaining equal, they are successful. Then at the point of time, it was said, okay, fine, let them apply for a tribal then, after they've obtained. Because sometimes there's instances where, there's some, we not need to say it in open court, but suppose our contract is worth around 2,000 crores, that kind of thing. And so like if something happened, that, so to avoid that, after you award, suppose 5 firms compete for these road infrastructure projects they all worth over 1,500, 2,000 crores. So those are the things. But then anyway, we'll not delve into that because that is not an issue here in this case. Regarding even that we can overlook. But that's the only thing. But then but the way you submitted your papers, power of attorney is in someone else's name, the retirement, and then your power of attorney is by a person who's not there in the original power partnership at all.
No, my lord.
Where's the retirement done?
Yes, my lord. I'll just take my lord to the documents that are required, my lord, because that is very important, my lord. Because my bid can be only rejected on the ground of non-fulfilling of the NIQ, my lord.
So this one retirement's on August 24. We can't split hairs. Where's the power of attorney again, Mr.
Power of attorney is in page 37, my lord.
This was submitted to the authorities.
My lord, although there are no
This was submitted.
Yes, my lord. Yes.
Yes.
My lord will see the NIQ itself, my lord. It only specify us submitting the power of attorney. Although as an act of abundant caution, whatever documents is there, it's submitted, my lord. But the NIQ itself says
Well,
specifically.
you submitted the other retiring partner, whatever partner was made, and then this power of attorney was made which date?
Whatever document is there, we have submitted, my
It's
lord.
made
But
on with the date?
Date of what, your honor?
September. This is power of attorney. August he retires. September. Yes. Yes.
So, my lord, whatever documents that is required under NIQ, my lord, we have submitted it before the.
What's the other ground of rejection?
Other ground, my lord, is that I have not given my technical specification of the manufacturer in the brochures, my lord. They have rejected. They have quoted this. Then B10, page 44, my lord, of my petition. (44) B10, my lord. Under the heading of technical bit, my lord, B. Yes, clause 10, which says product catalog brochures with detailed technical
You didn't
specification.
enclose this.
We have enclosed, my lord.
How will you sit on that? This is
no, my lord.
Anyway, your case more importantly is Mr. Nobi's case, because this case there is no interim orders in this case, correct?
No, my lord. But if this interim order is vacated, it will also affect my case, my lord. It will become infractuous, my lord.
Okay. Yes. Anything else?
Well, only one aspect, my lord.
Now next, Mr. Changriso's matter.
These two petitions, so I'm raised as a respondent matter. If you allow me, would like to file a short counter regarding these two writ petitions.
After hearing for so long.
Lordship is, I thought Lordship is hearing for the interim.
Interim is decide everything, Mr. Changriso. Can you file by tomorrow? File by tomorrow. We'll finish off with it after.
So
I've heard Mr. Nongri and Mr. Shalla. Heard Mr. Philemon Nongri, Learned Counsel, Ganikatika 478. On its objections to the vacation of the interim order dated 17/12/2024, and also made Mr. J. Shalla in WPC number 480.
Yes, madam.
Yes, which was in the same subject matter and issue. Mr. H. L. Changraisu, however, appearing for one of successful tenderers in WPC number
to both the
478
in 478 and 480, prays and allowed 1 day's time to file a short reply. To what? To the short reply to the affidavit.
But he has to support the vacating, my lord. He's on the same page with me.
Let's see what he says.
More or less the same, but
now you see the earlier case of the consultant, you don't know what counsel have in their minds now. Maybe the thinking process is totally changed. It's influenced by AI, what I don't know. But how they attacking the cases, we feel old now. Because we have a very formal way of looking at problems and trying to solve them. And now the way they're attacking them, not from the head first, from the tail, and from the very very difficult. Yes, which is also applying for respondents, for the private respondent in these two matters, prays that he may not find affidavit, short affidavit. Yes, when?
Whenever Lordship permit me, I will file it.
But we file it by the after tomorrow. The after is Wednesday.
27th.
This matter taken up 27th itself.
My writ petition, Your Lordship, allow me, give me 5 minutes only.
Now?
Yes, my
Of course. Yes. Your opinion?
Against the reply by the state, if I may be permitted to file the joiner.
Yeah, by the 27th one.
If possible.
Mr. Firmal also submitted, if advised, a short journal be filed to the affidavit by the state respondents in 478 of 2024.
Will a copy of the affidavit be served to respondent? They have not filed reply on my case, my lord. The state
Your case is unconsequential, Mr. Shila.
Then these affidavit filed in other. I'm also a party, my lord. If the state can serve.
Just like a substitute player on the line. You know, main player still playing inside the field.
The main player falls ill, my lord.
Anyway, yes. Affidavit, they have not filed affidavit. They don't need that, will cover your case also.
If a copy be served, my lord, of the state.
You already have a copy, correct?
No, my lord.
Then Mr. Initialite is also will also serve copy of affidavit filed in WC 478 to Mr. J. Shulai.
That will be a ground of appeal when Mr. Shila goes and file an appeal, but that no counter has been filed refuting all the.
Now we have to, you know, so yes, 5 minutes you said.
My lord, I'll take a short time. But I'll not go to other details. Only, my lord, the discrimination.
In your case, everything remains equal and you give 28% only. Are you registered in West Meghalaya?
My lord, that is not required under my lord. I'll just show the tender document in IQ, my lord.
No, when IQ says that, you must be registered MSME or something like that.
But those are procuring policy also there, my lord. Lordship, kindly come to page number 17 of my writ petition. That is the NIQ.
I would like to raise a point of maintainability.
Let him raise. Let him raise.
Which has been issued in his favor.
Let him raise. I'll show, man. I'll show.
Unaccepted, your lord.
I will show, man. If Lordship permits me.
Can you see?
Yes, you accepted. You already accepted the offer.
I'll come to that.
Then
I'll come to that.
You understand? Have you sent the petition that you accepted the?
I'll come to that one, man.
Have you signed the agreement?
Yes, your lord.
My lord, that was confined to 25%. My lord, 25%. Lordship, kindly see my protest letter.
You have to have the cake and eat it too.
Yes, my lord, 25%. My protest letter, page number 41. Lordship, kindly see.
Mr. Chaneso, we'll hear you on after we finish other matter.
No, my lord, here I also filed a interim application for seeking for interim protection. Lordship, kindly see page number 41.
Acceptance.
I request the respondent, my lord. This is my case, Lordship. When Lordship allow me to open, my lord.
Yes.
My lord, page number 41 is the protest letter put up by me, my lord. Now, however, I would like to highlight the following points for your kind information and immediate action. During the price bid opening on Sunsearch, we discovered that both technically qualified bidders had quoted identical amounts in their bid price. Under the principles of fairness and equality, we expect the supply order to be issued to both qualifying bidders in equal proportions. We learned from your esteemed office that the total requirement was such. The order received such bundle is significantly is less than 50% of the total requirement. That in fact we received less than 25% of the total order, with the remaining order being awarded to other party, despite both the parties being technically qualified and having quoted the exact same amount in their bid price. We are accepting the current order under formal protest, my lord, and strongly requires that fairness and equality be maintained in the distribution of work. The unequal allocation of supply order contravenes the standard procurement practices followed by the central and state government across the country and principles of equitable treatment. So with regard to, my lord, we accept this one, my lord, page number 35. The work order issued to me. Well,
has there been any precedent like this where this has been done?
My lord, in the NIQ, the quotation is, my lord, the clause is there, my lord.
It must be there, your lord.
The clause is there.
Has it been?
It must be there.
My lord, in IQ, I'll show.
Both of them, they are parallel, your lord.
My lord, in IQ, the corrigendum, my lord, if I take lordship attention to page number 32 and 33, the corrigendum in IQ was stands clarified. And it says, my lord, page number 33, the ending part. If the rate quoted by the quotationers in the same stage, the provision of clause 8.1 of the Meghalaya Procurement preference policy for micro and small enterprises 2020 shall apply. And decision of the entire committee shall be final and binding. Now, this was modified. It was modified, my lord. If the rate quoted by the quotationers is in same stage, the decision of the tender committee would be final and binding. My lord, now the technically, financially, both of us standing equal, my lord. Now, only my grievance is, my lord, if it is equal, and if the contract cannot be moved further, they have the power to scrap it. I have no right to insist that award should be given to me. But if they proceed further and give award, my lord, equitable distributions, right, the fairness comes into play. So if, my lord, I'll cite one judgment, 4 judgments are there, but
Yes,
I'll cite only one
your
judgment.
authorities
Well,
would like to examine.
my lord, 2000 volume 5 SSC, page number, my lord.
You just give the list?
I've given the list.
Let's see. Well, that also the court can understand. Why if they are, if both are the same, everything equal.
Yes. 2000 volume 5 SSC, page number 287.
There is a policy to that extent.
Well,
I'll place that.
Well, I will come to page number 10. The principle is well settled, madam.
Para 10.
Para 10, madam. My lord, if lordship permits me. There have been several decisions rendered by this court on the question of tender process. The award of contract and have evolved several principles in regard to the same. Ultimately, what prevails with the courts in this matter is that while public interest is paramount, there should be no arbitrariness in the matter of award of contract, and all participants in the tender process should be treated alike. We may sum up the legal position thus. The government is free to enter into any contract with citizens, but the court may interfere. My lord. But para 2 is important, my lord. The government cannot arbitrarily choose any person it likes for entering into a relationship or to discriminate between persons similarly situated.
Yes.
Equally, my lord, applicable in my case. Another judgment, my lord, if I may please, 2008, my lord, volume 10. ACC, my lord, 404.
So what's the differential that the government employed to give the 35-25?
Exactly, my lord. Lordship.
Yes.
Page number 39, may I take, my lord?
Page number 39.
Para 39, my lord. Para 39. So. Para 39, if lordship allow me.
Yes.
It's a tender matter, my lord. Another distinction in the approach of the court in this behalf must also be borne in mind, namely that a court may exercise its power of judicial review at the threshold of formation of a contract, as also the case in such, and the cases where the terms and conditions of contract are to be enforced. Whereas in the former case, the court's jurisdiction is wider, in the latter it is not. We may, however, hasten to add that it does not mean that the court may not interfere, even in a case where the term of the contract is against the public policy, or where in enforcing the same, the state acts arbitrarily, unfairly, or unreasonably, or makes discrimination among the persons similarly situated. Another judgment, my lord.
Yes.
2012, volume 8, SSC, my lord. 2012, volume 8, SSC, page number 216. My lord, para 24.
This is Michigan drama. Para 24.
Para 24, my lord. It says, my lord, therefore, a court before entering in tender or contractual matters in exercise of power of judicial review should pose to itself the following questions: whether the process adopted or decision made by the authority is malified or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational that the court may say the decision is such that no responsible authority acting reasonably and in accordance with the relevant law.
Note the judgments because 27 will be taken up. Yes.
Para 24.
I have a stronger trump card, my lord.
Well, and the last decision, my lord, the right of the participants, in fact, well,
yes.
That is a 2013-5 SSC.
1 second. Para?
Well, this will be, my lord, para 29. My lord. 2013 5 ACC 182. And the right of the tenderers are very limited, my lord. Page number 182. Para 29, my lord. Para 29. Merit, my lord. That this court in Meerut Development Authority case has laid down the legal principle that the bidder who has participated in tender process has no other right except the right to equality and fair treatment in the matter of evaluation of competitive bids offered by the interested persons in response to the notice inviting tenders in a transparent manner and free from hidden agenda. The relevant paragraphs such and such matter. But what I entitled is the free matter, the fair treatment.
Bidders entitled to, as a matter of right, insist authority inviting tenders enter into further negotiations. Yes. Okay, fine. But now the things that no, Mr. Johnny Sir, only thing you already accepted you signed agreement also.
No, my lord.
Then,
my lord,
how can you wish that away?
No, my lord. My protest agreement, protest letter is very clear.
Does it make that is there any provision for making a protest agreement?
Oh, my lord, when the tender is issued, and he knows that it is less than 25.
Fine. But
So
then you have accepted 25%, correct? Then
but under
that seals the deal.
My case would be different. With due respect, may I submit. If I submit the acceptance, my lord, without any protest,
I don't accept this 25% because unfair and arbitrary. Then we can understand maybe you have some ground, moral ground to stand on. But now you accept it, you shook hands on 5%, and you taken under protest.
My lord, my case would be different.
Does that position matter when it can be reassessment?
My case would be different if I accept it without any protest. Then I have waived my rights. I waived my rights, madam.
Whether there's anything has ever happened before that you give and then under protest it's corrected.
No, I was assured. I was assured that this work order is a preliminary nature. Therefore, you accept this one, my lord. Therefore, my lord. My lord. Therefore, otherwise, my lord, the no reasonable tenderer, my lord, sitting in the armchair of equality, would never accept 25% and allow other person to take 75%. But my acceptance is under protest, my lord. My lord, the author of the...
Where in commercial law is now suppose you take contract to build an airport under protest, you're building half of it.
No, my lord. If my protest acceptance is not permissible.
Under protest, the rates are very small. The roads from here to Nongstown, I'll build only up to Mongap. It can't be like that.
My lord, if my acceptance is without any protest, that is another, my lord. My protest letter is very clear. And if it is unacceptable, authority would have rejected my application. They didn't, my lord. They did.
They accepted. They said that fine. We give 25% more.
But under protest and urged them.
Where have they allotted that 25% to you? Where is it given?
My lord,
25% to.
My lord, page number 41. My protest
41.
letter.
No, your protest where they've settled the bid for 10% with the.
My lord, that is the page number 20.
What's it? Media roofing.
Power roofing.
Yes.
Power roofing. Sorry.
Power. My lord. We will see, my lord, the same terms and condition. There is no material to show that he is standing in an advantageous position. Therefore, he entitled 75%. I only entitled 25. See, my lord. Lordship, kindly see. Page 34 is the award for the private respondent, my lord. Page 34, annexure 4.
Page 35 is yours.
35 is mine, my lord. Now it says supply order for supply aluminum sheets, my lord. Now, with reference to above, I am to request you to kindly supply the aluminum roofing sheets as per the following specification destination.
Without looking to your case, if you want to know from the government on what reasonable criteria of consideration you give to 2020.
That is the issue, my lord.
That
is the issue.
Lots of permits, there is a policy.
There is a policy. That policy, my lord, I'll show.
Yes. Where is it? Is it flagged?
My lord, page 549 internal, my lord. Yeah. Just third or fourth page. 549. Preference clause 8, my lord.
It's strange, my lord. The state is not replying, my lord, to the lordship's question.
Lordship, before coming.
You don't arrive as a respondent. I'll not say anything.
First to the NIT, your lordship, at page 21.
Lordship, kindly come.
See, one does read a preference. MSE is registered a policy entitled for price preference up to 20% over the L1 price. If one happens to be non-registered industry supply and policy.
So, my lord, we were entitled to price preference even if our price was 20% higher than Mr. Sangresu's client.
That is not the case. It is not the case that my friend has quoted lower.
It's on record anywhere that they've resorted to this
yes.
policy. No, in your government record.
Kindly come to page 21, Your Lordship.
Of the
writ
petition.
Of your writ petition, Your Lordship. That is the 3, Your Lordship. Page 21, 3.
3?
Your Lordship, from the technical bit, Your Lordship, kindly come to page 21.
Yes.
Then that is A initial bit.
Yes.
Then Lordship, kindly come to
3.
The serial 3, Your Lordship. If the rate which is by the application of clause in one of the measures of Macron shall apply and the decision to the committee will be final or binding.
My lord, correct. That is then modified, removed by page number 33. Lordship, can you see? By Corrigendum, page 33.
Of your petition?
Yes. And nothing is reflected even in the minute also read out by the other side in the other petition. My lord, can you see page number 33, the last portion? Clause A technical financial bit. This is the one, my lord.
This is a corrigendum.
By corrigendum, it was modified before technical bit was open.
Okay, they give full liberty to the committee.
My lord. So that policy is not enforceable, it is not applicable in this
case. In effect, they've just implemented the policy only, the committee.
They say it is not applicable.
Have you filed affidavit here?
They are yet to file.
Today?
Last time it came up, Lordship fixed the matter for motion. So I pray, my lord, let them file a short counter.
Then 27 my lord. Now 25.
And decide together, my lord.
Yes. I've heard with HL Raiso, there is counsel with petitioner. Very interesting case. Yes. Issue notice. Issue notice, Mr. Andy Shulai. Mr. Andy Shulai with notice on behalf of 1, 2, 3 and Dr. N. Mozika with
number 4.
Number 4. This on 27th for instructions.
Maybe added as parties, but maybe we have a thing or two to say with it.
How do you add as parties now? There's not too many fish in one small pond. Yes.
Interim orders to continue.
Yeah, till 27. Yes. But Mr. Chandesu, you have to overcome that obstacle because it's a contract. Remember that. It's a contract. So, like,
What? Item number 2.
Keep the average.
That's the matter. I'm not going to the orders. Yes, that's the matter. Yes.
Matter was fixed for hearing on the application filed by the respondent on perjury. We are being led by Mr. Jindal. He's on legs before the division bench. I was praying
by Mr.
S. Jindal, Lordship. He's on legs before the division bench matter. So I am praying for if it can be taken up at the end of the list, Lordship.
No, at 2 o'clock then.
Your Lordships, I have a request. Your Lordships, I was requesting for a time to file the rejoinder in this.
What rejoinder? Have you filed an application?
They have filed an application saying that I have committed certain perjury. I have filed a show cause. Now there is no question for them to file a rejoinder on that.
What rejoinder you want to file?
Your Lordships, yes.
Is it already on record? I mean, the application for filing rejoinder? You have filed for adjournment?
Yes,
then,
Your Lordship, the
matter is fixed for hearing today, Lordship.
Your Lordship, the only reason why I am requesting for the permission of this Honourable Court to file the rejoinder, because Your Lordships, the perusal of the reply filed by them, it relies on certain RTI information which they have taken, and these are the factual aspects, Your Lordships, which need specific reply. Your Lordship, the only issue is because I could not seek permission of this court, that's why the rejoinder could not be filed. It's in the process. I have instructions, Your Lordships.
They put an application?
Rejoinder
because these matters are becoming, just,
in my humble submission, this is nothing
that,
they
just,
the dilatory tactic, Lordship. They have filed an application saying that on record I have committed perjury. I have filed a show cause. Now, where's the question of them coming and filing a rejoinder on some factual situation?
Your Lordships, because the documents they are relying on, they need specific reply. The documents
They have to show
required.
from the record that I have committed a
In
perjury.
RTI,
That's all.
in RTI, your lordships of July 2024, they
Okay,
have a specific.
you're allowed.
Please,
Yes,
please
you file your
specify,
application,
your lordship.
Mr. Pala. We'll take it about 2 o'clock. Yes.
Please, your lordship.
You can make your objections then. Yes. Yes.
Deeply obliged, your lordship.
Item number 2.
Yes. You have some objections?
Absolutely, my Lord. Lordship himself has noticed on the last occasion, Lordship has observed that these are transparent attempts to delay this matter, my Lord, and render it infructuous. A petition was filed last year. We filed a show cause on 25th November. Since then, they've perused the show cause, and today, after 4 months, they say we want to file a rejoinder when the matter has already been heard in part in February itself, my Lord, on 4th of February, I think. Lordship has heard it in part.
So, my Lord, if I may submit, the matter was never heard. On the first occasion, Your Lordships had heard the application partly, to which the reply was filed. Now, considering Your Lordships, kindly see page number 15 of the reply which has been filed by the Council for the Election Petition, Your Lordships.
This is Miss Case number?
16, my Lord. 16.
Yes, at page
15, Your Lordship.
15.
Please, Your Lordship. 15.
Yeah.
Your Lordship, they are relying on this RTI dated July 2024. However, the application was moved in November 2024. Your Lordships, these are the certain factual aspects which have to be dealt with, Your Lordships. We need to file the rejoinder to this, Your Lordships. And what my learned senior friend is saying, that the matter was argued at length, it was never argued. Only when the application was listed for the first time, Your Lordships had heard the application, and thereafter their reply was filed. On the last occasion, I could not appear in the matter because there was no permission from this Honourable Court to file the rejoinder. I could not, Your Lordships. Therefore, today I am seeking the permission.
And you will give them 1 week. Yes, I've seen an application for adjournment. So for rejoinder. Praise a lot for reasons stated therein. Rejoinder should be on board within 1 week. Whether it has any substantial importance on it, we don't know, but
The position, my Lord, is very simple. They are accusing me of lying. I am saying I didn't lie. That's it. No rejoinder is required for that. Anyway.
Item number 3.
Grateful, Your Lordship.
within 1 week, we will upload this after 2 weeks.
Please, Your Lordship. I'm grateful.
Lord, here I'm praying for a week's time, Lord, for filing affidavit.
You have not filed affidavit till now.
No,
When will it file the matter?
It could filed due to the officers busy in the election duty. I can file
When
it.
election duty?
My Lord, this side, my Lord, because from the
matter
director's office.
You have filed since July 20 last year.
My Lord, in fact, it is ready. I can.
Mr. Bharatsaji, I don't understand why you have so much problem filing affidavits. You have to put in a new regime in place. You filed 18 July.
My Lord.
I can file it within this week, in fact.
Yes, and you've been appointed.
Yes, Lordship. My affidavit is in Lordship waiting for the signature. I can file it this week, Lordship.
You've been appointed. You've taken appointment. 1 man selection, 1 man interview.
Yes, Lordship.
And you, Ms. Amari, pending for whom?
I have entered a place for the respondent number 4, but we have not received any proper instructions.
The managing committee, my Lord.
You are for number 5, correct?
I'm for 5.
Yes, class positive 1 be granted to the respondents number 1, 2, 3 and 5. 1, 2, 3 represented by Mr. K.V. Bharatsaji and 5 by S.A. Sheikh to file the affidavit stuff. Mr. M.U. Ahmed submits that he has not receipt of any instructions. May list the matter after 2 weeks for admission hearing. Otherwise, we can't carry on like this. July to now. I can understand 1 month, 2 months. It's not empty threat. Of course, officers here. Let them bring the records and we will dispose of the matter.
I'll do that.
My Lord, we are filing the rejoinder affidavit, my Lord, in course of the day, my Lord. We are in the process of filing in, my Lord. I have served the copy to the other side, my Lord.
You receive copy? Yes, sir. This matter for hearing after 2 weeks. Yes.
Well, interim order may kindly be continued.
Interim order continue. Yes.
Item number 5.
Please, Lordship.
Yes.
I make a small submission in this case, Your Lordship. This ask for this
the temporary appointment of the Gangbora that has been expired on 22 January 2025. And my second prayer is I have challenged this order to set aside, and another part of the prayer is to conduct a fresh election. Now, since the interim appointment of Gangbora has been already expired, no, the order can be passed. There will be there be a fresh election.
Who is appealing for the council?
And secondly, my lord, in their affidavit, my lord, they have admitted that there should be an election. But in the para 10 of the affidavit filed by the GHDC.
Mr. Sangma?
Yes, lordship.
Is he been extended or is still continuing?
My lord, I'll take instruction on that. I'll just 1 week time maybe given to you. He was sick, lordship, because he was having some surgery, lordship. That the respondent number 4, lordship.
Where's that impugn order?
Lordship, it is the page 30 of my writ petition, my lord. The Annexure 8.
Okay.
So it is stated with effect from 22.
Has been renewed.
I have to take instruction, because today the matter is otherwise fixed for affidavit of respondent 4. So they can clarify.
Who's this 104?
I'll take instruction, lordship, on the day.
Yes, Mr. P.D. Sangma has submitted that the challenge to the impugn order may perhaps no longer survive, as much as the temporary appointment of the respondent number 5.
That's number 4.
Number 4 has expired on 22/1/2025 as per the appointment order dated 31/7/2024. Stop. Next, but this submission, Mr. S.A. Sheikh appearing for respondent number 4 and Mr. Deb for the Garo Hills for respondent 1, 2, 3. Period 1 week's time to obtain the instructions.
Instructions.
Yes. One more thing, lordship, whether now they can extend when the subject matter is subjudiced before the court.
Now, after this,
because the court already. What's blessed, lordship.
My lord, in terms of the last order, the respondents were supposed to file.
Mr. Shulai.
Lordship, yes. May it please you, Lordship, I'll need some time, your Lordship.
What's the matter about?
Lordship, this is regarding complaints against the managing committee, Lordship. More specifically against the secretary and the president.
6 and 7.
Lordship, inquiry is still going on. We haven't received the inquiry report. We have to bring on record the inquiry report, your Lordship.
What inquiry report?
Lordship, there was an order, there was a request by the director, your Lordship, to the DC to cause an inquiry into their
allegations, Lordship,
allegation made in the complaint.
That's over.
Lordship, I'll have to take instruction whether it's over or not.
And you're appearing for?
I'm appearing for the respondent number 5, and the secretary of respondent. We have not received proper instructions.
What are proper instructions and improper instructions?
We have not received proper instructions. They might engage new counsel.
Yes, Mr. Anish Shulai, then the AG submits that they are still awaiting the outcome of the inquiry.
Lordship.
That is being conducted by the subdivision.
By the Deputy Commissioner, your Lordship.
Deputy Commissioner. What regard to what is the order for inquiry?
No, Lordship, there is an request from the director to the Deputy Commissioner, your Lordship.
On 5/12, they submitted by its state respondents that cause of action no longer survives. You know, the fact a complaint which petition has been filed has since been withdrawn.
Another complaint is there, your Lordship.
No, Dari. It was being conducted by the district school education officer.
By the Deputy Commissioner, your Lordship.
Where have you submitted that earlier on? Is it recorded early any order?
No, your Lordship, there is an I have the instruction, your Lordship.
Share that with the court.
I'm sure. Though this is a letter of November 24, your Lordship. Magisterial inquiry, your Lordship.
Against this respondent number 5, 6, and 7.
Lordship.
Against you.
He's respondent number 4 and 5, Lordship.
Who's 4?
He's the secretary, president and secretary, Lordship. The
No
managing
one's
committee.
appearing for 4.
For the respondent number 5, secretary.
Then who's for 4? Again.
Service has been affected, my lord.
Never appeared.
Never appeared, my lord.
Who is Akas as president, not secretary?
President, my lord.
5 is secretary.
Secretary.
Yes. And MS Emraman appearing for 6 and 7. But your performer respondents. Okay, Mr. Andy Shulai, the EAG, has submitted that the affidavit, the filing author will have to await the outcome of an inquiry which has been requested by the Director of School Education Literacy, Meghalaya Shillong, by the letter dated 13 November 2024, addressed to Deputy Commissioner West Council Stura. Stop. He prays for is allowed to obtain instructions in the meantime as the outcome of the said inquiry. So, MS Emerwan praying for 6, Mr. MU Ahmed praying for number 5. Submits that he has not received any proper instructions on the matter and such, unable to file an affidavit. And you?
I need 2 weeks time, Your Lordship.
MS Emre Haman for 6 and 7, please fill out further 2 weeks time for affidavit. With regard to respondent number 4, it is noted that though notice has been service been effected, no appearance has been made till date on the respondent's behalf. This is the matter after 3
weeks, Your Lordship.
Yes.
Apply, Your Lordship.
Item 7. Lordship, praying for further 3 weeks time as the conducting counsel is not well for the petitioner.
They're supposed to file the rejoinder, Your Lordship.
Rejoinder affidavit.
You already filed?
No, they have not filed yet.
How many times you prayed for gender?
This is the second time.
Your name?
M. Thakuri.
Who is conducting counsel in this case?
A. Sahad.
Who?
H. Sahad.
Where is he from?
He's from Guwahati.
2 weeks further time for rejoinder is allowed. As a final opportunity, it's a matter for hearing the meantime is.
Item number 8.
Thus, the service of notice has been affected, Lordship, and to that effect, an affidavit has also been filed upon the respondents 6 and 7.
Your Lordship, on behalf of respondents 1 to 4, I'm praying for some time to file our affidavit.
6 and 7 is whom?
6 and 7 is the Rangmashnong and the secretary, the Rangmashnong Rinja.
You're appearing for them? No, I'm for respondent. 7 have not appeared?
Never, Lordship. Previously also an affidavit has been filed when the notice was affected through registered post AD, and thereafter last by order dated 5/2.
Mr. Upadhyay submits that Dasi service has been affected upon the respondents number 6 and 7. Stop. However, there is no appearance on their behalf today. Next paragraph, MS, then now complete 1 to 4. You're filing no affidavit, no? 1 to 4. Raise funds allowed for a 2 weeks time to file affidavit. Stop. Report present June. Then the list the matter after 2 weeks for affidavit by the state and for appearance of 6 and 7. Next time we'll pass all of the ex parte.
Lordship.
Obliged, Your
What they see in the affidavit first.
Yes.
Item number 9.
Here in this case, what happened, Lordship? I was supposed to file one impleadment application, impleading the first wife, Lordship. But subsequently, Lordship, the petitioner has received 2 letters from the AG office that the department has corrected the nomination in the service record, and accordingly the department, the AG has acted on it, and that PPO has been generated, Lordship.
In your favor?
Yes, Lordship. So at this stage, Lordship, I'll just take one more so that
we won't keep it pending pension matters.
Only.
Yes, this is dated 17 December.
7 December.
Mr. S.E. Sheikh today has submitted that though permission had been taken from this court to impede for the necessary parties. Though permission had been taken from this court to impede further necessary parties, he has come with parties. The same will no longer be necessary, inasmuch as from the office of the respondent number 5, communication has been received that the PPO in favor of the petitioner is being processed. Stop. You've seen this document? Yes.
That is why I was saying, if one more chance is given so that they can have instruction.
No, I'm done, sorry.
Even
have been taken from this court. Process. Communication to that effect is also produced over the court. The same is taken on record. MSEB Pasa appearing for respondent number 5. Please were allowed to obtain instructions on this. Instruction you don't need.
The government lordship, because that lingua is the council.
For the state respondent, you also pray they without 1 week's time to obtain the C instructions on this development on this matter after 1 week.
Obliged, Your Lordship.
Awesome.
Item number 10.
Give them a copy of that.
Fine.
Yes.
May it please Your Lordship. Lordship, we have filed the affidavit, Your Lordship, from 10 to 14, Your Lordship.
We have received the copy of the affidavit today, my lord. So I'm praying, Lordship.
What's the matter about?
Lordship, here, Lordship, what has happened is, Lordship, I was appointed in the year 1993 in the post of laboratory technician, Lordship. Thereafter, Lordship, my post was confirmed in the year 2019. Now, Lordship, in the year 2023, they have issued an order saying that I am an ad hoc employee and they have regularized me from the year 2023, Lordship.
Okay. Yes, you're a rejoinder, no?
Lordship, I'm praying for 2 weeks, Lordship.
How many petitioners are here?
Lordship, altogether 5 petitioners are there.
Lordship.
You file affidavit all of them?
Lordship, yes.
Yes, Mr. Indishwara submits affidavit on behalf of the state response has been filed. Mr. Chanda for the petitioner, please be allowed to examine the same and to file rejoinder if necessary. It's a matter of 2 weeks for rejoinder, if any. Yes.
Apply, Your Lordship.
Till item number 14, Lordship.
Till 14.
15.
Your Lordship, as per the last order, respondent 1 to 3 has yet to make an appearance.
I'm entering appearance on behalf of respondent number 1 to 3.
I'm appearing on behalf of respondent number 4, Your Honor.
You, Mr. Kriam?
Yes.
Have you filed
I'm
affidavit?
seeking 2 weeks' time, Your Honor, to
What about number 5?
Is yet to make appearance.
Number 5 is whom?
CM of Maram.
CM.
You're paying CM Haram? No.
No, on behalf of the Rangbak Snong of Wayloi. Respondent 4.
What's the matter about?
It's about an impugned order, Your Lordship, passed by the executive committee.
Passed by the tribunal, Lordship.
With regard to this boundary?
Boundaries.
Yes, Mr. S. Chanda today has entered appearance on behalf of respondent 1, 2, 3 and prays the allowed. How much time? 3 weeks' time to file affidavit. Similar prayer by Mr. Sorry, your name? Marwan.
Yes.
Marwan on behalf of number 4. Praise aloud. Has he been served? Number 5
has been served.
This one number 5. It is noted. It is submitted as part of service to enter appearance. Well, this is a matter after 2 weeks, 3 weeks for affidavit and for appearance of spot number 5.
Similar prayer on item number 16.
16?
16.
Same respondents?
On respondent number 4 and 5.
The respondents are different.
Yes. You are appearing here also, Mr. Chandra? It's the same matter.
It's from the same impugn order, but then the matter is a bit different.
Yes, 4 and 5 appearing here. Mr. Imarwa is present on behalf of respondent number 4 and 5. There's no appearance on behalf of response 1, 2, and 3.
And 6.
1, 2, and 3. District Council, brackets Council, and number 6. That is the
CM.
CM Aram again.
CM.
Yes. This is matter together with WPC number
42.
42 next day.
17.
May I please, Your Lordship? Lordship, we are not filing any rejoinder in this matter. I pay that matter kindly come for hearing.
You won't file rejoinder?
No, Your Lordship.
Some submits that no rejoinder is necessary. Stop, accordingly it's a matter for hearing.
Your Lordship.
Yes.
God bless, Your Lordship.
Yes, Your Lordship, I'm for respondent number 6. I would need some more time for the affidavit.
But I only think there is an interim order that will have to be explained.
What about
Respondent 1 to 5 and
7? What response are they? Are here? You're appealing for whom, Mr. Marpan?
Respondent 5 or 6, sorry.
6 is whom?
6 is that Good Village.
8 served. Mr. Sen.
Yes, my lord, we have taken steps.
Yes. You're appearing for the tribunal also?
Yes, Your Lordship.
Also on behalf of respondent number. You're with Mr. Kharsad. What's your name? Sorry. Yes, Ms. D. Congwer for 1, 2, 5, and 7, and Mr. S. Marpan for 6. Brief one allowed for a 2 weeks time for affidavits. No appearance is made. No appearance will be in behalf of respondent number 8. Stop. That's interim order of any should continue till the next day.
Acknowledgement.
19.
My lord, I am appearing on behalf of respondent number 6. My lord, I need 2 weeks time to file affidavit, my lord.
You only allowed 2 weeks time last time.
Last time I made the first appearance.
Yes, it was complete praise for allowed 2 weeks time. What instructions do you need?
My lord, there are certain documents we have to translate, my lord. It will take time.
What's the matter about?
So it's regarding where for respondent to direct the issuing of license, Your Lordship.
License to?
License
oh
to
yes,
the
that
petition.
we pay for the
In
darbar.
regard to the bar. Yeah, I'm for the darbar, my lord.
Why not giving license after giving? Why take it away?
My lord, there was some objections from the locality.
Then before granting the license, you didn't take, the objections were not, no objections were there.
That time it was issued there after the question raised by the residents and urban organization also, my lord. That is
Who gave the initial permission?
Initial permission,
Then?
Darbar is given, my lord, first. Then thereafter it has to be withdrawn because of the compulsion and pressure from the residents of the locality as well as the women organization, my lord. So we will give our
Mr. Rinja, 1
defense,
to
my
5, yeah, and you're appearing for? Oh.
She's
And you're appearing for 1 to 5?
1 to 5.
You're not filing affidavit?
My lord, I have just received the instruction.
Mr. N. Singh 1 to 5, Mr. Charnar for 6, 3 for allowed for a 2 weeks time to file affidavit. Any interim order?
No.
Is a running bar or is closed?
For running bar, Lordship.
It's closed.
It's closed means it is the initial stage, Lordship.
Never opened.
Permit. License is granted. Only permit for procuring.
And my lord, because the law requires that they should take the pass, the permit to lift the liquor.
To lift the liquor.
So only for lifting purpose, my lord, they are having problem because there are so many objections that has been filed. So ultimately, my lord, keeping in mind the public interest, my lord.
22.
Published. Amid pieces, your lordship. Lordship, this matter will need some more time, your lordship. At least 3 weeks time may be allowed, your lordship.
Your Lordship, this is regarding the termination of service consequent to a disciplinary proceeding that was drawn up by the police. Correct,
There was
Your
a delay of 14 years, your lordship. 14 years, if I remember.
Yes.
Yes, as prayed for the 2 weeks time allowed for affidavit. Is there outcomes also?
Apply, Your Lordship.
Hearing 25.
Yes.
Your Lordship, I pray that this matter may come up after 2 weeks, Your Lordship.
Why? You're the counsel here.
No, Your Lordship, Mr. KP Bhattacharjee is the counsel.
He's there just now. Where is he? Call him.
Your Lordship, he left, Your Lordship, to pick up his son from school.
That's not an excuse you should make in court.
I'm praying that I'm a teacher working in the school, Lordship, and my prayer is to get the sanction post. Because my father had donated the land wherein the school has been set up.
What is your interest? You're a teacher teaching that post.
I'm the managing committee, Lordship.
What's the problem in accommodating this person?
No, Lordship is aware that there are only 3 sanction posts, Lordship. Now he is a SMC appointed teacher. Now what she is making the claim that father has donated the land. That is also incorrect, Lordship, because the land was donated by somebody else. But now she is saying that the land was donated by my father, but the gift deed is executed by other than her father, Lordship. Now all throughout she has been working as a SMC appointed. Now she is claiming that I should be appointed as a
serving as SMC teacher also.
He is still serving.
But you're not getting a salary.
No.
Why?
Because school managing committee has made a resolution that 6 teachers are appointed in the school, but sanction will only come for 3. So they have the right to take the salary from the government and disburse it equally among the 6 teachers and the other staff of the school. Whereas government has approved my appointment, being the.
Where's the approval?
Lordship, we kindly see the approval of the writ petition, Lordship, page number 58, the last page. First approval, Lordship, will kindly find at page 46 first of the writ petition, page 46.
What about this? How do you, Mr. Sheikh?
And again at
this being the candidate from family landowner.
Lordship, there is an inquiry.
Then
inquiry was.
Where's he filed affidavit?
I filed it.
What do you see in affidavit?
In the affidavit, we are disputing, Lordship. Now, kindly see my affidavit, Lordship. That is
at page 44.
Page 46 was my first approval, also by the government.
Yes.
And subsequently, I had again made certain representations because this dispute of who has donated the land and all had come up. Inquiry was held, and again I have been approved, Lordship, by. And if Lordship is again pleased to see page 58 for a moment.
Yes, it's seen.
Copy to number 4, the person concerned, Srimati Sujita Das, 4th teacher.
Why a 4th teacher? He'd be 3rd teacher.
There are 4 in Meghalaya. I have come across a notification where they say if the number of students are above a certain level, there can be a headmaster and 3 more.
So you're not a sanctioned teacher. You're outside the. You see 3 sanctioned posts only. 3 sanctioned teachers.
4, Lordship.
The first time I've heard there are 4.
No, there is a notification. In certain matters I have seen, Lordship.
Where are those certain matters?
I can produce it on if it's above a certain threshold.
Produce it. In the course of hearing, it is seen that the writ petitioner provided an order dated 26 October 2018 had been approved as an assistant teacher of Majipara SSA UP school. As the 4th teacher of Majipara SSA UP school. Stop. Mr. S. Deb Council submits that be allowed to bring on record the fact that in some schools where the enrollment is higher, there are 4 sanctioned teachers.
But in that school, Lordship, the government is not giving any grant to the 4th teacher, and 4th teacher has subsequently approved.
So you're just using the services.
He is SMC because
you're just using the services or paying.
Because that is why, Lordship, it was in 2010, Lordship. So there is a details inquiry report.
Let them produce that if it's a 4th section.
Issue has come with a resolution where they said that 6 teachers are there. We are getting sanction for 3 plus a headmaster. so we'll distribute it amongst the Sikhs and the
Should be
staff.
happy
And all.
with that amount.
Whereas I have donated the land, I want to be the sanction teacher because that was the understanding.
You
At
take
the
back the land now.
Sometimes
They'll remove the building.
Lordship, sometimes he pray that I should be appointed as a sanction, and sometimes some resolution that I should be appointed as a fourth teacher. But her claim is very not certain. Which post she is claiming?
No, my claim. I'll put
Depending on her mood, I think.
Obliged.
Lordship, this is a second round of litigation, Lordship. The petitioner has been denied promotion due to lacking of ACR criteria. So initially had approached this court, and this court has directed that the entries should be communicated and represented. Now he has preferred representation that has been rejected as well. So we are challenging
He's done the second. They've been provided the ECR for the relevant years.
They've only provided the points. So against that, I've represented myself. They have rejected by way of a speaking order, and now I have challenged. The speaking order is at page Lordship 156, 156, annexure 19. So relevant paragraph will be at page 157. Paragraph 5B, Lordship.
Page?
Page 157. Paragraph 5B.
Yes.
Lordship, am I allowed to be read?
Yes.
B. In the instant case, the petitioner came up for promotion to the rank of Subedar General Duty as per his seniority in the year 2021 and in 2022, and was screened by a departmental promotion committee along with his batch mates in the year 2021 and 22. However, the petitioner was found to be ineligible for promotion due to lacking in annual confidential report criteria, as he was found to have been graded high average 5 points in the annual confidential report for the year 2016-17. Whereas to become eligible for promotion, he should have been graded above average 7 points or outstanding 9 points. Therefore, he was superseded for further promotion. C. On perusal of the annual confidential reports of the petitioner from the assessment year 2021 to 2022, it has been revealed that he has been graded average 2 points in the annual confidential report successively for the assessment year 2007 and 2008, while in the rank of Havildar General Duty and high average 5 points. In the rank of Subedar General Duty in the annual confidential report for the assessment year 2014-15 and in 2016-17. Assessment and grading awarded in the annual confidential reports by officers and reviewing officers are purely based on the performance of during the assessment periods. Hence, award of 2 consecutive average 2 points grading in the rank of Havildar General Duty and high average 5 points grading twice in the rank of Naib Subedar General Duty have been taken into account, which clearly reflects the performance of the petitioner. Lordship, the ACR criteria is the relevant years is 5 years. Now, Lordship, they had taken into account from the year 2001 to 2022, Lordship. Now they had ventured into other years also, Lordship.
So for the years which you had not supplied to you, which one?
16-17.
Yes, 16-17.
The criteria is that I should get
high average.
Lordship, the eligible criteria is 7 points, Lordship. I should be graded above average, but I was graded 5 points.
17. What was your grading?
My grading is 5 points, high average.
It's low. I mean, you won't be in a zone for consideration or promotion.
Lordship,
it should be high average, correct?
High average. I should be 7. I should get 7 points at least, Lordship.
They didn't give you 7 points.
No, only 5 points.
So,
Lordship, there's no.
What's your case?
My case is that there's no reasoning, there's no finding in the impugn order as to why I was downgraded from 7 to 5 points. Because Lordship may kindly come to the ACR which of the year 2000.
What was the issue from the same year? Knowing that you graded average 2 points, was 70 were not bothered. When the rank of Havildar General GD and high average in the rank of Subedar first one is also high average only. Why is he downgraded?
No reason, Lordship. There's
Why do you see him being downgraded?
We don't know, Lordship. Lordship, can you come to the ACR? The relevance ACR is at page 82. They have not provided me this ACR, but they have enclosed it in the counter affidavit in the first round of litigation, page 82, Lordship.
Yes.
Lordship, can you see this is an ACR for the year from 1st September 2016 to 31st August 2017. This is the ACR in which, Lordship, can you come to, Lordship, in the first page, just the bottom, Lordship, there's a grading column there, the bottom, the first page. Left hand side bottom, Lordship. It says grading.
Yes, 7R.
IO 7, initiating officer 7.
Downgrade, but then no comments are here. 5. Now
5.
Reporting officer says 5.
Reviewing officer and senior reviewing officer says 5, Lordship.
Yes. So you didn't agree with the 7 regrading.
Lordship.
Then?
Lordship, can you come to page 85?
85.
85. Lordship, can you come to para 15, point 15?
Yes.
This is the initiating officer.
He will give you 7. Which is physically fit and robust. He enjoys good command control over his subordinates and is dependable. Okay, 7.
That is his assessment over me, Lordship.
Was given assigned duty dedication, but given 5.
Yes.
And then the senior SRO gives you high average JCO. I agree with the assessment RO. I use liberal assessment. So fine.
Lordship, can you see the date? Lordship, can you see the date in which the SRO has signed this SER, Lordship?
19.
2 years, Lordship.
No, but he has agreed with that, with this
no, Lordship.
5.
He's not the officer which I had worked under him, Lordship. In no manner, he cannot even greeted me.
What about the reviewing officer?
5 points, Lordship. But Lordship,
he
can you see the comments? The comments, Lordship. This is nothing adverse against me, Lordship.
Right.
But strangely, the SRO
reporting officers to liberal.
Strangely, the SRO's Lordship, he signs the ACR after 2 years. This is ACR not 17-19, Lordship. This is 16-17. This is done malifiedly, Lordship.
Malifiedly?
This is done just to just to deprive the petitioner of his petitioner, Lordship.
Before you file the petition, the second one.
Lordship.
And before you file the first petition.
Lordship, this has been annexed by them in the first round, Lordship.
That's what I'm saying.
Lordship.
It's after you file the petition that you got.
Lordship, what I'm trying to say is that by the speaking order, Lordship, there's no finding why they have downgraded me. Lordship, the IO has given me 7 marks, 7 points. Now the RO has given me 5 points. But where's the reason in the speaking order, Lordship? There's no finding to this.
But why you downgraded from 7
why,
to 5?
Why I was downgraded? There's no warning letter, no nothing. And it goes against their view, Lordship. Kindly come to page 86. The adverse points they have to communicate to the concerned officers, Lordship. This has never been done. It's only after I've approached this Honorable Court. So the first ground in which it's speaking order is illegal, arbitrary, and discriminatory, Lordship. There's no finding why I've been downgraded from 7 to 5 points for the year 2016-17. Second point, Lordship, the ACR, the SRO has graded me in the year 2019 after 2 years.
Anything that does anything.
It has an impact, Lordship, because he's not the concerned officer in which I have to work under him. After 2 years, Lordship, had this ACR be of the year 2018-19, then I'll have no quarrel, Lordship.
Thing is that now, private respondents are represented.
No, Lordship.
Notice was served.
Notice was served, Lordship. There's an order.
The thing is that when were they promoted?
Lordship, they were promoted on 1st 11 2020. 1/11/2021, Lordship. Lordship, I'm also praying for a retrospective promotion.
You submitted a petition. They have not addressed that at all, you mean to say?
No, Lordship. No finding, Lordship. And they venture into 2002, 2004, 2005, which is not even relevant for the concern promotion.
They have not. If the representation are only for upgradation of ACR, have you not addressed the issue why you don't get it from 7 to 5?
So the speaking order of what's given here, I cannot improve this. So
No, not mean cannot improve, but I mean, is a speaking order, has it spoken about the representation, has it addressed representation of the writ petitioner? Or just that the
It's a
speaking...
mere formality, empty formality, Lordship. They've only said that you got only 5 points, that's why we cannot accept your representation. But what's the reason to that?
Where's the representation?
My representation will be at which?
You know, this the speaking on 30th November 2023.
My representation is at page 144, Lordship.
One four four.
144 is the representation, Lordship.
Yes. See, the court order says you have to take into where's that reply? 157. 157, right?
156 is the speaking order, Lordship.
Why retain hence award of 2 consecutive average 2 points in the rank of Havildar GD? Where's that? Where's the 2 points?
Lordship, the relevant ACR which the respondents should take into account for promotion.
Now you say that that the whole thing revolves around 1617 ACR.
1617, Lordship.
And then the very fact that downgraded from 7, which the initiating officer gave you, to
Yes.
5 has affected everything.
Yes.
Now what about the earlier years where
That is not relevant, Lordship.
15, 14, 15 is 5 years for promotion. That means 14, 15, 16, 17. Then
Lordship, but the adverse remark is in 1617, Lordship.
whatever it is, what about this? They say that for assessment and just read this part. Assessment and grading so and so based on in the rank of award of 2 consecutive average 2 points, the rank of Havildar GD. Which year was this?
Lordship, the petitioner was working as a Naib Subedar.
No.
He
Which year was
supposed
this where you got 2 average 2 points?
Lordship,
Which year?
I don't know, Lordship. This is
So
their speaking
where
order.
does it come from?
This is the speaking order, Lordship.
Where does it come from? I mean, this average 2 points.
That only the respondents will have to answer this, Lordship.
Mr. Devnath, what is this? I mean, it refers to which year average 2 points? They've not said why they've downgraded to 5 points. They say only hence award of 2 consecutive average 2 points, grading rank of Havildar General Duty, and high average 5 points, grading twice rank of Naib Subedar have been taken into account.
Lordship, he's not even Havaldar, Lordship. He was Naib Subedar. He was required to be
Where
promoted.
does it come from? That's what
We don't know, Lordship. This is the order passed by the respondents.
$15. What was your post holding? 15, same.
Paragraph C, you know, 5C.
Exactly, you've seen that. 21, which year is this? We've given 2. 2001 to 2022 is 21 years. For which year is given 2? 2007-2008 can be taken to consideration for promotion. Last 5 years ECRs have been taken. See, Mr. Devla just sees on. See, on Pula, it's ECR for the petitioner from SSME 1122 has been revealed that he has been graded average 2 points in the ECR successively for, he has given SSME 2007-2008. So, is 7 and 8 would take in consideration also?
That's what
As per this, see, this is there in perusal of the annual conference.
No, see, please try to understand. Will the year 2007-2008 come to consideration or not for the constitution promotion? That's all you have to say. And if it doesn't have to come consideration, then this order is wrong. And if they don't explain why downgrading is represented, nothing, just says that whereas in careful examination entire service records of the petitioner, high average, and then they revert back to 16-17. See para 6.
Yes.
You forget about that 6 and 7, about those two.
Lordship, the petitioner was initially recruited as a GD. Then he completed his training. Then he got his promotion. He got his promotion as Havaldar in the year 2000. Then he was promoted to the rank of warrant officer in the year 2011. Then in the year 2013 was promoted as Naib Subedar.
13 Naib Subedar.
13 is Naib Subedar, Lordship. 5/10/2013.
Mr. Jadman, please explain. Warrant officer when? 2011.
Lordship, warrant officer on 1/6/2011.
And before that, initial appointment as?
Was recruited as GD, Lordship.
Rifleman.
Lordship.
Which year?
4/7/1986.
86.
Lordship. That is when he was enrolled in Assam Rifle. Then he was promoted to the rank of Havaldar on 1/12/2000.
Yes, Mr. Jadman. Please enlighten. Whether this order has complied substantially with the order of the court. Dated? Which order of the court dated? 23. When?
24/8/2023.
We'll give you one more day. You kindly just clarify at that point. You're not prepared today.
After going through this one, I was having some.
After you going through this one, then you realize that you're not prepared.
I can help my Lordship.
How will you help?
Page 73, Lordship. Page 73. Which ACRs are relevant for my promotion? Page 73. From the year 2015 to 2021. These are the relevant years, Lordship.
You come to see this matter in the course of hearing. Mr. Jadman prays him allowed to prepare the matter further. You just remember those points. Otherwise, the speaking order is not a speaking order at all. And if you've taken into consideration irrelevant, years, that means
31.
Obliged.
State?
Sure. Sir KP is
Who?
Sir KP is appearing on behalf of the state.
He's going to beat his own drum. Yes, ready?
Your Lordship. Yes, Your Lordship.
But you don't have that. What is the
This is with regards to the delay in regularization of my service, Your Lordship. After I've been confirmed in service, Your Lordship.
You're already retired now?
Already retired, Your
When you
Lordship.
retired?
On 1st March 2019.
Lordship, in this matter, the respondent before have basically no role to receive any papers relating to the pension and other benefits, Your Lordship.
No, the
Only
common
dispute.
counsel is not here. What to do?
Your Lordship, my case is covered by this Honorable Court judgment, Your Lordship, passed in WPC 36 of 2022.
Let's see. Call, where's what's her name? What's that, country? Yes. Here is the matter. Yes, MS Sham. What's wrong? Why can't I come to court? Yes.
Lordship, my instructions are that the matter is still under consideration with the government.
It's under the
As
hearing
in
stage
the-
now. It's not an order stage. What does it say in the affidavit?
As per the last communication, Your Lordship, the proposal for regularization, that is annexure 10th of their affidavit in opposition, is still under examination, Your Lordship. The proposal for the regularization of service of the following staff is under. And the last communication was on 12 September 2023, Your Lordship. It has been almost 1.5 years.
You know pension till now. You got pension.
No, Your Lordship.
Yes. Take down. Yes. Let's just see the common affidavits. Yes, the writ petitioner is before this court with a prayer for post facto regularization and for finalization of the pension due, apart from other terminal benefits, as admissible. Stop. Next paragraph. The brief facts are that the petitioner was initially appointed as stenographer grade 3 in the office of the District and Sessions Judge Long on 27/4/1988, and her name thereafter had appeared in the provisional gradation list of the staff of the District and Sessions Judge establishment. By office order dated 14/5/2014, the writ petitioner was confirmed along with others in the post of stenographer grade 3 and thereafter had continued in service the factum of her impending retirement was also communicated to the Treasury officer by a letter dated 30/7/2018 in connection with a subscription towards a general provident fund account. The petitioner thereafter had superannuated on date 1/3/2019. But however, till date is yet to receive a pension and other retirement benefits. Stop. Next paragraph. It has been submitted by MS Arkachi that in spite of the petitioner being confirmed in service against a vacant sanction post, and in spite of her name appearing in relation list, the respondents have not processed her formal regularization, which has compelled her to approach this court by the instant writ petition. It is further submitted that the Learned Council has also drawn attention of this court to various communications whereby the service books and other relevant documents have been transmitted by the law department to the personnel department for regularization. Stop. Though these communications are dated dated 3rd August 2023 and so on, she submits the fact that the petitioner has been serving since 1988 is undisputed. Stop. She therefore prays that directions be issued for immediate regularization, formalization, and for release of her pensionary benefits. Next paragraph. MSS Sham, on behalf, appearing on behalf of the state respondents, has only submitted that the proposal for regularization of the state petitioner is still under consideration, as referred to a letter dated 12 September 2023. To show that the same is under process. Stop. MS EV Pasa.
Ready to receive the pension welfare.
Yes, MS EV Pasa for respondent number 4.
Yes, Lordship.
Submits that from the side of the Accountant General, they yet to receive any
pension papers,
any materials or papers
and on receiving
to
of the
process
side letter.
to process the pension, to process the pension of the petitioner, and
on receiving of
on receive of any such papers, the same shall be dealt with expeditiously by said respondent. Next paragraph. I've heard the counsel for the parties and also examined the materials on record. It is noted that I've seen that sometime on the record. The writ petitioner is seen has been subjected to immense hardship and suffering due to no fault on her part, especially considering the fact that she had been confirmed in the post as far back as in 2014. Stop. A judgment rendered by this court. Oh, no, what I thought before her submission from Askasian. Regarding submission to Askasian, first submission, how she ended that submission. Raise that so and so. Yeah, in support of her submissions, Your counsel has also placed reliance in the judgment of this court dated 29/7/2022, passed in the OPC number 36 of 2022. Rama? And have been appointed in the year 1988 itself on a regular scale of pay, correct? On the regular scale of pay, correct?
Yes, Your
On regular scale of pay with all other service benefits and also contribution to the GPF fund. It is not understood, therefore, as to what has prevented the state respondents, which has since received the service books of the petitioner and all necessary records to process the proposal for regularization and to regularize the petitioner against the post to which he had been serving. Stop. It's further noted that after the letter dated 12 September 2023, nothing is known as to the progress of nothing is known with regard to the progress of the case of the petitioner. But what this court notes with and I thought that, but it's no, before the sentence. So the petitioner stop. The petitioner accordingly, next paragraph, accordingly is directed that the respondents shall process the case petitioner most expeditiously within the period of 2 months from the date of this order and issue necessary orders in this regard. Stop. It is to be kept in mind that 6 years have elapsed since the retirement and no pensionary benefits have yet reached the petitioner. Stop. Next part, the petitioner as ordered above, writ petition is allowed and is disposed of. Yes.
Hello.